We are live. We are live. Welcome to College Football's Peek Around the Corner with your host, Greg Flugar. We cover everything, and I mean everything in college football because we love college football, and if you do as well, please subscribe to our channel. Smash the like button. If you like our content, share the video with your family and friends. If you want to support this channel through a donation, just hit the $sign, make a comment, and I will get to your super chat as quick as I possibly can. Welcome into the studio that sits on the corner of Keith Jackson Parkway and Kurt Gowdy Avenue. Do not be afraid. Do not be afraid to be a legend in the chat room with the comments or with your phone calls later in the show. This morning, PATC, College Football's Peek Around the Corner breakfast show. We're going to be doing some live coverage. Leon County Part 2, Judge Cooper, Florida State versus the ACC. Now I'm hoping it happens like April 9th, where there will be live coverage in the courtroom, and then we're going to show it to you live. We're going to do a live stream on April 9th. Before we did it on April 9th, we talked to some people. They said you should not get in trouble with YouTube, and we did not. There was cameras in the courthouse. We did a lot. We were able to take that. I don't take people's live streams. If I did, without their permission, this would not be a channel anymore. But we were told that it was going to be fine. We did it. YouTube gave us no issues. So we're going to do it again if they have a live camera in the courtroom, and I think they will. We are following some people that are going to be in the courtroom. So I think we're going to be able to do both, just like on April 9th. We're going to watch it ourselves, put down your comments, and we're also going to be reading comments of people inside the courtroom. I want to thank everybody who's come on in already. Holy smokes, it's 8:05 and the chat room is filling up. I want to say thanks to everybody. I want to get to an article that was written, Amanda Kristovich, Front Office Sports. Let's set the table. The proceedings are scheduled to begin 25 minutes from now. 25 minutes from now. Now, April 9th, it was supposed to last 90 minutes. It lasted 7.5 hours. And we were here for the whole duration. We'll see what happens today. We'll see what happens today. We will be here as long as it takes to cover the story, because the college football's peek around the corner. We go where the story goes. That's what we do here. We go where the stories take us in everything in college football. Kerry Gold Nose, yo, thanks for coming on in. Early Peak member, Minnesota Seminoles is here. Randy Taylor, Michael Batts, Morgan Fralick, the Walking Geek is here. Skaven, yes. Hello to the Mad Gopher. Hello to you. Chief Fan is in the house. Mr. Terrapin, JD Turtle. Carson, we are live. John Till, I haven't seen John Till in a while. He is in the house. Bill G. Stephen McNeely, wake me up when something important happens. Michael Monk is in the house. Mr. Cyclone, Matt Neeson is in the house. CFB playoff edits. Judge Flugs is back in session. Man, if I was a judge, there would be no justice. We cannot let myself be a judge. Jay Chapman is in the house. Deadeye, Regal No was right. All right. There's a Regal No fan in the house. Tom DeBay is here. Juan Carlos Nelly, and good morning. Bob Weevil is here. Expedition Greg. Dad Mac. Stephen Clark. Are you Muggs? Suzanne is here. Mr. Monkey says, Early Peak member DP is in the house. Clemson alumnus. Another Mr. Terrapin. D5 Terps is here. Kevin Ellis. Brett Taylor. Are you going to be having the live stream like last time? We are going to make every attempt to do that. I have two news stations all set up. If one of them pops, we're going to be on it. We believe we are going to be able to do it, Brett Taylor. Now, I cannot completely promise it, but if there is a camera, if there is live video, we're going to be covering it. Mr. Brett Taylor. Gavin Hackman is in the house. Kerry Gold Nose, thank you so much for your super chat. Good morning, Greg and PATC fam. Gold Nose, thank you so much for your continued generosity to this channel, helping us keep the lights on. Thank you so much, Kerry Gold Nose. Jimmy is in the house. FSU is in the house. Thomas Hickman. Go Terps. Cloak and Dagger week begins. Yes, you are correct. Nick Snyder is here. James Diaz, Bobby Davis. Wow, wow, wow. We got a lot of things going on here. We got a lot of people coming on in early in the morning. Raider Vision. Texas Tech Red Raider. Jay Go Blue. Thanks for all coming in. I do appreciate it. So let's set the table here. The proceedings are going to begin in 20 minutes. 20 minutes, Leon County, Judge Cooper, Florida State versus the ACC. This was last night, or I'm sorry, yesterday. We provide a link in the description box. You can read the whole thing. Everything you need to know about the legal attempts to kill the ACC. 4 lawsuits between the conference and members, Clemson and Florida State, could determine the fate of the ACC. The lawsuits address whether or not the conference contracts are legally enforceable. Again, Amanda Kristovich, Front Office Sports, link is provided. We are 20 minutes away. 20 minutes away from the proceedings beginning this morning. We're going to be covering it live. Last month, during the first round of the NCAA men's basketball tournament, ACC Commissioner Jim Phillips sat beside Clemson's athletic director Graham Neff. In a normal year, this situation would be standard operating procedure. The pair, likely assigned to the seating arrangement by the NCAA, might be sharing small talk and celebration as the Tigers beat New Mexico 77 to 56. After all, their first win in what would become an Elite Eight run was good for both the conference image and its finances, thanks to the tournament prize money system referred to as units. But, nearly a year removed from last summer's major wave of realignment, the vibe was decidedly icy. The two did little more than acknowledge each other's presence when Neff sat down midway through the first half. Otherwise, they weren't particularly chatty. According to one reporter on the ground, another reporter likened the scene to a botched wedding city chart. Neff got up at halftime and he never returned. The prickly dynamic was the result of a rather significant off-court dispute. Clemson is suing the ACC, following the lead of Florida State, which fielded a similar lawsuit in December. Their goal proved that the contracts binding them to conference aren't enforceable, winning them the right to leave. The ACC, meanwhile, in its countersuing both schools in a court in North Carolina like a domestic partner making a last-ditch effort to save a relationship. Here's everything you need to know about the 4 lawsuits that could break the ACC apart again. Amanda Kristovich, Front Office Sports, we're going through it. We are 17 minutes away. 17 minutes away from the proceedings beginning in Leon County, Part 2, in front of Judge C. Cooper. Slow down a second. I don't remember lawsuits from last summer's realignment. Why is this different? Conferences generally have 2 marriage contracts, a media rights deal and a grant of rights, which allows the conference to sell media inventory for the schools on their behalf. Schools looking to depart their current conferences generally have 2 options: wait until these contracts expire or pay the exit fees. The Pac-12, for example, broke apart because its previous media contract was up at the end of the 2023-24 season. Most of the schools refused to sign the deal they were offered, as well as the gore that goes with it, so they were free to go. The Big 12, on the other hand, negotiated a deal with Texas and Oklahoma to allow them to leave a conference a year early before their previous gores expired in 2025. ACC schools don't have that same flexibility. The ACC's contract goes for another 12 years until 2036, several lifetimes in the rapidly evolving college sports landscape. And the exit fees are much more expensive than they are for any other conference. Think, well, adding an extra zero. Again, we are 15 minutes away from having live coverage. Leon County, 15 minutes away. Who started this gaggle of lawsuits? Technically, the first one was the ACC's complaint against Florida State, filed on December 22nd in Mecklenburg County, North Carolina. But that was filed in anticipation of Florida State's lawsuit, which appeared in Leon County, Florida court the following day. The ACC was fully aware that Florida State was planning its own lawsuit, as was the rest of the internet. University's officials suggested in a public board meeting announcement earlier that week. In fact, a couple months prior, they talked about it in a public BOT meeting at Florida State. Clemson filed a complaint 3 months later on March 19th in Pickens County, South Carolina. The ACC followed up with a countersuit the following day, also in Mecklenburg County. Why now? Why now? Schools like Florida State and Clemson have witnessed other conferences wheel and deal to add new valuable members, increase their media rights fees like the Big Ten and the SEC Super Leagues. Florida State, in fact, have been considering for over a year whether or not to sue to get out of the ACC. Florida State has accused its conference of shirking its contractual obligations by mishandling media rights negotiations and conference realignment over the past several years, dooming the conference to fall significantly behind its competitors financially. The last straw, the very last straw, however, was the most notable. In December, Florida State failed to secure a spot in the college football playoff despite going undefeated, while one-loss Alabama locked down the final spot. A move that was largely credited to its SEC affiliation. We are 13 minutes away from covering live in Leon County. 13 minutes away. We're just going through an article from Amanda Kristovich, Front Office Sports. We are setting the table for today's proceedings. After Florida State put its foot down and sued in December, it was only a matter of time before Clemson followed that lead. Are Clemson and Florida State's arguments the same? Not exactly. Florida State's complaint includes multiple arguments demonstrating the conference general negligence, Seinfeld airing of grievances, as I wrote in December, but it focuses specifically on the enforceability of the grant of rights and interpretation of the multi-decade media contract with ESPN. The gore, which Florida State called draconian, which would require $572 million payout, including a $140 million exit fee to leave the conference before it expires in 2036. Florida State also argued that the ACC misinterpreted the media contract with ESPN. Same argument Clemson's been making, and we'll circle back to that later. Our last live show on Saturday night, we hit that pretty hard. If you missed it, we'll go over it again later on today. Clemson's lawsuit appears to be somewhat less accusatory, as it only echoes Florida State's sentiments about the gore. It doesn't include a referendum on the conference failures as a whole. You mentioned countersuits. What's the ACC's game plan? We are 11 minutes away from the proceedings starting in Leon County. We're going to be covering it live here at Peek Around the Corner. 11 minutes away. Hoping for a home field advantage, the ACC filed counter lawsuits against both schools in North Carolina. Florida State will potentially have the sympathy of a local Florida court judge in its lawsuit. Same goes for Clemson in South Carolina. The AC is hoping that its countersuits will not only provide a friendlier venue, but ultimately end up halting the lawsuits in the school states. Even if those attempts fail, the ACC could at least set a precedent for litigating contracts in any state where the conference operates. This practice is a slippery slope, however. The judge in the Florida State ACC case accused the conference of forum shopping. Judge C. Cooper. During a hearing last week, while not illegal, the practice is frowned upon by judges in many cases. Many of us readers aren't lawyers. How exactly could these lawsuits cause the breakup of the conference? We are 10 minutes away. 10 minutes away from the proceedings starting in Leon County, Part 2. We're going to be covering it here at Peek Around the Corner. If Florida State and Clemson prevail in the court and invalidate the gore, they would break the bond holding the league together. The schools would be able to take back the rights to broadcasting their own games. And most importantly, they won't have to worry about coughing up 9-figure exit fees to find a new home. But finding a new conference is much like finding a new partner. You might end up staying in your current relationship, even if it's not perfect, especially if you can't find anyone else. Florida State has been vocal about its interest in joining the SEC. Interesting. It's an interesting take by Amanda Krisovich. I think Florida State has been vocal about having the opportunity to discuss their options with SEC in the Big Ten. I don't quite take it as interested in joining the SEC. If that's their only option, yes, they're going to do it. But I think Florida State, Clemson just wants to have the ability to have serious conversations with the SEC in the Big Ten. Right now, they cannot have first party talks with the Big Ten and the SEC. The Big Ten and the SEC will not risk those serious first party talks. And then she goes on to say, but the SEC hasn't appeared interested in courting them because they really can't. But at that point, the ACC headquarters would have no control over its fate. We are 8 minutes away. 8 minutes away. We're going to be covering it live in Leon County. You mentioned ESPN, which probably has invested several millions in the ACC as its media rights holder. Surely they have something to say on all this. In fact, they do. ESPN, which has invested hundreds of millions into the conference, has not taken a public position on the main questions in the lawsuit. But it does agree with the ACC on one thing. It wants the terms of its media contracts discussed in all the lawsuits to remain private. Through a glitzy New York City-based big law firm called Cravath, ESPN filed a brief asking the court to seal the contents of its agreements from the public. That 17-page document suggests the contracts include trade secrets and that Florida State may have even committed a felony by disclosing some information about the terms already. The motion was generally successful with a few exceptions. We are 6 minutes away. 6 minutes away from covering the proceedings in Leon County live. 6 minutes away. We are setting the table with an article from Amanda Kristovich, Front Office Sports. When Clemson filed this lawsuit a month later, it heeded ESPN's warning by filing a redacted complaint. So what's next? How long will this take? On Monday morning in Florida, it is Monday morning right now, and we are 6 minutes away. On Monday morning in Florida, a judge will hear arguments whether to dismiss the Florida State versus ACC case, and as a result, let the North Carolina countersuit go forward instead. It's unclear how long these cases could take, as there's always a chance for a settlement, but at this point, we don't even know which of the 4 lawsuits could yield a decision that would be considered precedent. Both schools appear to be potential fits for the SEC, though, as I mentioned, the Super League would have to extend those invitations, the SEC. Look, they're not even having first-party talks right now. I know a lot of people disagree with me on this, but they're just, none of that is happening. We are not at that part of the story yet. There is no negotiations going on between the SEC and Clemson, SEC and Florida State, Big Ten in Florida State, Big Ten in Clemson, Big Ten in North Carolina. None of that is happening. There has been no invitations. No matter what you hear from anybody else, there is no invitations. There's not even an application. Unlike Florida State, which has voiced its desire to leave the ACC, Clemson has clarified in public comments that it just wants to explore the option. We are 4 minutes away. 4 minutes away. We're going to be covering this live. Now, this is what Doug Rohan, a friend of the program, this is what he expects. When asked, what do you expect for tomorrow, Monday? This was asked of him yesterday. Doug Rohan puts out a post, says, great question. I do not expect many fireworks tomorrow. Judge Cooper seems reliably in the camp of Florida State. So he will hear the arguments on the issues of 1, dismissing the complaint filed by Florida State, and 2, whether or not to stay discovery in Florida as requested by the ACC. I would expect a ruling from the bench on both issues. I expect him to deny both motions. Then we move back to North Carolina for May 2nd, and Judge Bledsoe will decide if discovery is paused pending a ruling on the appeal to the North Carolina Court of Appeals regarding that judge's first order, not staying or holding the North Carolina case until Florida case is decided first. After that, discovery will start for both cases, and then we will start talking about mediation dates. Doug Rohan. So that is where we're at. And live proceedings should be starting in 2 minutes from now. We're going to check out to see if we can capture a live stream. Thank you, Carrie Gold Knowles, for the gifted membership. Holy smokes. Thank you again for your generosity. A lot of gifted memberships through the month handed out by our very generous community. Carrie Gold Knowles, you are hereby granted Cloak and Dagger Knighted once again. Thank you so much, Carrie. I appreciate it. And Thomas Hickman, you were gifted a membership by Carrie. Please say thank you to Carrie when you get a chance, Mr. Hickman. And you are officially knighted Cloak and Dagger. And you can watch our membership-only episodes that come out once or twice a week. Just go to our YouTube channel. Now, let's go check it out here. Let's go check it out. What do we got? I am checking. I am checking for a live stream. Don't have one yet. Now, keep your head on a swivel. If anybody picks up a live stream, send it to me direct message at Flug Empire on X. Neither one of the live streams from last time is they're not running it right now. So keep your head on a swivel. Let me know. There is belief inside the courtroom. There is a belief inside the courtroom that WCTV will be having a live stream. It sounds like they are there in the courtroom. Again, I do have WCTV up, but it doesn't look like they've started their live stream. I do not see a link for it. I will keep an eye on it. But somebody in the courtroom does believe. Both legal teams are in the room shaking hands. This information is coming from Florida State 247. Crab Cakes and Football, thank you so much for your generosity. Thank you so very much. You are hereby officially knighted Cloak and Dagger. Crab Cakes and Football gifted a membership to somebody in the community, and this time it was Bo Stacker. Bo Stacker, when you have a chance, please say thank you to Mr. Crab Cakes and Football. Bo Stacker, you are hereby knighted Cloak and Dagger. Bo Stacker, a Turk gifted a Mountaineer is a wonderful thing. Thank you, Crab Cakes and Football.
Oh my God!
Beautiful, beautiful. The moderator, the one who rules with an iron fist, taking a little break at work. Thanks, really, thank you for your support. We do appreciate it. We appreciate all the support that you have all given us. Gator Hater is in the house. Yeah, we just don't have anything going on yet. At least I'm on the both sites that we had last time. But it does look like, now I don't know why I closed that out. Let me see here. I do not have the stream has not started yet, and but I don't think anything has begun yet in the courtroom. The lawyers are there, but according to people in the courtroom, it hasn't yet begun. So we haven't missed anything yet. As far as I believe, anyways. I don't think we've missed anything yet. By the way, to any Florida State Seminole fans out there, at midnight last night, you were able to start communicating with people that are in the portal. And I'm keeping my eye on Florida State because there's a wide receiver in the portal, a transfer from Georgia named Tyler Williams. True freshman last year, played in 2 games. He's raw, but he was like the 17th rated wide receiver in the country last year. Went to Georgia, went in the portal. Now, I know the Gophers are targeting him. Now, you say, how can the Gopher get Tyler Williams? Well, we're probably a long shot, but there is a connection between Tyler Williams and the coaching staff here at Minnesota. And we are in the hunt, even though we're not the favorites. But we're in the hunt. But Florida State's going to be looking at a couple of wide receivers in the portal. One of them, probably Sam Brown, the guy from Houston, who used to be a West Virginia Mountaineer guy. Somebody who's been productive, who's been in college football a couple of years, whatever. Somebody like that. Somebody who can be wide receiver number 1, wide receiver number 2 for the Seminoles. And then they're going to be looking at maybe a guy who they need to develop. I'm just saying, Mike Norvell, Florida State, leave Tyler Williams alone. Because if you go after him, he's from Lakeland, Florida, I believe. If you go after him, Minnesota does not have a shot. Now, no SEC school can go after him because he's a spring portal entry. And the rules in the SEC is that no SEC school can go after him. So, Gophers got a shot as long as Florida State keeps their hands off of Tyler Williams. Okay, do we have a live stream yet? Oh, it did open up. Hold on. Hold on, everybody. I still don't have it. Okay, we are in standby. Is this what everybody is seeing? Okay, that's what Rod Nix has got. Good. Okay. All right, we are on standby. Mireya says, Wapo, enjoy your day in PATC community. You are the best. Thank you, honey. I do appreciate it. Young Seminole, the only wide receiver they will grab has to have some size. Where Tyler Williams is 6'4". The thing is, he's not developed. right? He's not going to be able to help the Seminoles in 2024. If you go look at the ratings of who's in the portal, uncommitted wide receivers in the portal. If you look at, okay, I'm looking at 247 Sports. Their ratings for the top receivers in the spring portal who are not committed, Tyler Williams was ranked number 3. Now Sam Brown is ranked number 1. The other guys ranked around Tyler Williams have all had success in college football. I'm hoping Florida State sticks with the guys who've produced. Hidden Hawaiian is saying UCF for Carmani and Tyler Williams. That could be. We might not have much of a shot with Tyler Williams, but we're in the conversation. But yeah, UCF might be a great spot for Tyler Williams. Here we go. It's live. Thank you all for coming. PATC, Judge Cooper presiding.
Okay, this is on.
Judge Cooper, organized as ever.
I'm got 4 or 5 days until I have to do it. Okay, we're here on the remaining motions. Let me get this organized a little bit. So I'm assuming you all want to start with the motion to dismiss, handle that, and then go to the motion to stay discovery?
Yes, Your Honor, that would be appropriate. And
Okay.
Announce for the record, Alan Lawson, the Atlantic Coast Conference. With me is Amber Nunnally, who will be arguing both motions today.
Good morning.
Huck Gonzalez, Earl Houck, General Counsel for the Atlantic Coast Conference, and Jim Cooney, who's admitted pro hoc vice here and is handling the litigation in North Carolina. There's also a request for judicial notice. You properly ruled last week, last time we were here, that it was appropriate to take notice of matters that were filed in the North Carolina action.
Mm-hmm.
That's not saying that they're relevant or any of the facts in there are appropriately considered on any issue here, but with respect to that, we have no objection to that saying with an admission of those documents.
Okay, so tell me again, we're in the new password phase on the computer, so I'm going to go without this computer today since it's not syncing. Start without my data. Maybe it will sync. Hold on a minute.
Different camera angle from April 9th.
All right. Okay. What judicial notice have I not approved?
It was Florida State University's request for judicial notice of correspondence between the ACC and FSU general counsels.
Okay, so I will, no objection from either side. I will take judicial notice of that. It seems like I received something from Florida State Friday afternoon that said I was going to receive something, and I'm not sure did I receive that, Mr. Londot? The second thing?
It was hand delivered.
Okay.
I have copies of it here as well. It's the item that.
All right. If you need me to review it for the motion to dismiss, I probably should look at it.
It's, may I approach you?
Sure.
It's, for your binder, sir. It's an updated index with a new item 6.
Okay.
It was hand delivered Friday.
I-
It's not made its way.
I remember seeing this. My binder is here. So item 6 is board's request for judicial notice. And just so we'll have a good record, what I've just granted is FSU plaintiffs petition for judicial notice, Exhibit A, letter of January 12, 24. From ACC General Counsel to Egan FSU Office of General Counsel. Take a quick look at it. January 12.
This was supposedly hand delivered to the judge's office on Friday. The judge believes he might have it, but he did not look at it. Given by Florida State to the judge. This might take a while.
Okay, I have read it very quickly. I'll read it in more detail. Let me look at the second item, which is Exhibit B, letter of January 18, 24 from Ms. Egan back to General Counsel for ACC. This is Exhibit B. I've read that. It appears to be, in a very brief summary, an indication of some areas of disagreement between the parties.
Well, Your Honor, the relevance is that it was filed in a North Carolina action. That's the basis on which they asked.
Okay.
If there is any relevance.
These letters were filed in the North Carolina action.
Letters?
All right, and over a break, or when you need me to read these more thoroughly, I will, or point out to me the provisions from FSU or ACC that you think I need to read, but I'll keep those right here.
I will, Your Honor.
Okay. Let me turn to what I have in my notebook is ACC motion. I have the Atlantic Coast Conference motion to dismiss or alternatively to stay filed 2/16/24. Is that the document we're operating from?
That's correct, Your Honor.
All right, so I have some notes here. Here we go. I'm ready to hear your argument. I don't know, it depends. It depends on the lawyers if you want to go have ACC counsel go all the way through or break it up into subject matter and let FSU argue in response. I probably would just rule at the end on the various matters, which is why I'll be taking more notes than usual. So I kind of think we should break it up a little bit that way, but if there's a reason to do otherwise, I'm open to that too.
Good morning, Your Honor. I'm Amber Nunnally on behalf of the Atlantic Coast Conference. We're happy to break it up however you think is best, and so after each portion, I can pause and see if you'd like to have argument from Florida State in response before I move on to the next.
Right. I was just looking at the way the ACC motion is structured and thinking that those were good break points.
ACC's
In the
motion
That's
to
how I'll proceed then.
dismiss. That's
Okay.
the first part of the hearing today.
You may proceed.
Thank you, Your Honor. I'd like to start by going back to something that Mr. Lawson said at the very beginning of our hearing a few weeks ago, which is that this case is not as complicated as it seems. It's actually very simple. It's a contract dispute. You have two parties who entered into a business deal that one of them no longer wants to be a part of. And the nature of the contracts at issue, of course, involve large sums of money and very significant and important media rights, all of which the ACC takes very seriously. But there's been a lot of heated rhetoric and passion about this case that's really distracting from its simplicity, and I get it. I'm a double null. Florida State is one of the country's premier public universities. People's interest and concern in this case is justified. The ACC's mission, though, is to partner with universities to create well-rounded, successful athletes and people of character. That mission, which is carried out through athletic programs at universities like Florida State, matters to many student athletes and their fans. But as a result, the ACC is the most successful intercollegiate conference in the country in terms of athletic and academic achievements. In the past 2 years across all sports, ACC athletic teams have won 20 NCAA championships, 14 just in 2023. That's more than any other conference in the country. Your Honor, I'd like to spend just a few minutes, if I could, before I get into the merits of our motion, putting things back into the perspective of the contract dispute that Florida State's asking you to resolve. There are two North Carolina contracts at issue here. The first is the ACC Constitution and their bylaws, which FSU signed on to when it joined the conference in 1991. And the second is the Grant of Rights, which was initially executed in 2013 by Florida State, and then amended in 2016, also executed by Florida State. So the ACC Constitution, starting there first, that addresses the withdrawal of a member. If a member provides notice to the ACC by August 15th in any given year that they may wish to withdraw, they can then withdraw effective June 30th the following year. FSU's complaint about this part of the ACC Constitution is with the current amount of the withdrawal payment. They concede that they have always had the option to withdraw, and they still have the option to withdraw at any time. Their problem with the ACC Constitution is the withdrawal payment. The current payment that they would have to pay is equal to 3 times the total operating budget of the conference as of the date of the official notice of withdrawal. And as they alleged in the amended complaint, a member who wishes to withdraw today would be required to make a payment of $130 to $140 million. It's very important to note, though, Your Honor, that this amount has been in the ACC Constitution since 2012, for nearly 14 years. That's when it was amended by the ACC Board of Directors, which included the president of Florida State at the time and still does. Not only did Florida State agree to share revenues generated from media rights when they joined the conference in 1991, They also voted to raise the withdrawal payment to its current amount in 2012. Turning to the grant of rights, that's the contract between the ACC and the members of the conference where each member transferred to the ACC its media rights for home games. And in exchange, the ACC bundled those rights and then negotiated revisions to its multimedia agreement with ESPN.
That's the grant of rights?
Yes, Your Honor, that's the grant of
Media
rights.
Okay.
Granting the media rights to home games. ACC took those rights that were transferred to them by all of the members of the conference, bundled them together, and then negotiated revisions to their multimedia agreement with ESPN. That increased the fees. Those negotiations then increased the fees and royalties that are paid to the members for the transfer of those rights. And as amended in 2016, the current term of the grants of rights goes through 2036. I did want to just clarify that a home game is any game that is either played at a member's home location or in a location where the member is designated as the home team. And another very important clarification is that the rights for home games that were transferred and then bundled by the ACC is the right to broadcast a member's home game across the country, not just in a local area. 100% of the revenue generated from home games, such as ticket sales, concession sales, things like that, those revenues have always remained with Florida State, and they always will. That is not addressed at all by the grant of rights. It's simply the right to broadcast the home game across the country that was transferred under the grant of rights. Your Honor, after being an active and governing member of the ACC for more than 30 years, and after operating under and receiving the financial benefits of the grants of rights for more than a decade, Florida State is now asking you to invalidate the contracts they believe no longer serve them.
I think all they're asking me now is to deny your motion to dismiss.
That's true. They are asking you to deny our motion to dismiss, and if you deny our motion to dismiss, the next step would be that they're asking you to invalidate their contracts.
Okay.
Those contracts were a good deal when they signed them in their minds. They remained a good deal in their mind for many years. And it wasn't until Florida State read that other conferences may be getting more money for media rights agreements that were negotiated by those conferences after the agreement that the ACC negotiated with ESPN that they started complaining.
So can I ask you this? I've handled untold number of contract cases, both as a lawyer in private practice and in the current job I hold. Are penalties, either whether you look at North Carolina law or Florida law, are penalties, excessive penalties, enforceable just because they're in a contract?
Well, that would presume that the withdrawal payment is a penalty. That question would presume
Well, let's skip the withdrawal. Let's go to the grant of rights.
That would also presume that the voluntary decision to transfer the media rights to the ACC is somehow a penalty if Florida State now wishes to back out of that contractual obligation.
If it's determined whether in North Carolina or Florida that the grant of rights payments is an unlawful penalty, isn't it unenforceable even though it's been in a contract and it has been voted on, paid, or whatever, acted on over the years? Under Florida or North Carolina law, it remains an unenforceable provision of a contract if it's an unlawful penalty?
Yes, Your Honor. Of course, if something is determined to be an unlawful penalty, it would be unenforceable regardless of whether it was a provision of the contract that was entered into. But of course, our position here is that these aren't penalties, they're not unconscionable penalties, and they're not unenforceable.
Well, also in most states, I know it's the case in Florida, and I believe it's the case in most states, insurance contracts to insure a party against a punitive damage claim are considered unlawful in violation of public policy. That it's against public policy to buy insurance for your punitive conduct that would lead to punitive damages. This is, I'm not saying there's punitive damages here, but just in general. That's another instance where just because it's in a contract doesn't make it enforceable if it violates the public policy of the state law that applies, right?
That's right, Your Honor, but the withdrawal payment is not a penalty. It's not a measure of damages. It's the bargain for consideration for the option to withdraw. It's not damages that would be owed as a result of a breach.
And my hypothetical doesn't presume that there are any penalties here. I just want to understand or verbalize. I understand the importance of contract. It's very important. But just because two parties agree to something doesn't mean it's always enforceable if it violates the law of the jurisdiction that applies, correct?
Yes, Your Honor, as a general matter, that is correct.
Or if, and I'm not saying it's happening here, I'm just trying to establish some ground rules. If a contract has been entered into and as a result of misinformation given to one side upon which it relied, under some circumstances, those contracts can be rescinded or disallowed, correct?
Under Florida law, I can't speak to North Carolina law on that point, but under Florida law, under some circumstances, which did not occur here, that is also, as a general matter, correct.
Okay. Perfectly well. I understand the argument of ACC, and I've read it, and I'm ready to hear more of your discussion. I understand that. But it's also, while contract is very important, and in some instances, acceptance of contractual benefits could act as a ratification or waiver. That's the latter part of your motion under affirmative defenses.
Well, it looks like WCTV's battery went low. So
Is the standard when you're presented with a motion to dismiss. I believe that our motion lays out that even accepting those factual allegations as true, they have not stated any legally cognizable cause of action, but there actually are a couple more important threshold issues that, if I may, Your Honor, I can get to first. So we've stated in our motion to dismiss that there are multiple reasons to dismiss this complaint. First, that none of their claims are ripe. They have not sufficiently pled personal jurisdiction. Some of their claims are time barred. And then, of course, the discussion we were just having that all of their claims fail to state cause of action. So starting with ripeness, their entire amended complaint is a request for an improper advisory opinion from this court. All 7 of their claims are tied together by a single issue, that continuing the grant of rights and requiring the withdrawal payment to leave the conference are unenforceable penalties that somehow decrease competition or are otherwise a violation of public policy. But this is the most important fact that is alleged in their complaint, which is that Florida State is not currently subject to any of the quote, penalties that they're complaining about. Nothing in the amended complaint alleges that they are. Their own allegations make it clear that they have not made a decision about whether they're going to withdraw from the ACC. And that fact alone, full stop, shows that their claims are not ripe, and this is an improper request for an advisory opinion. And I can point you to page 3 of the amended complaint, where Florida State says that they want, quote, guidance from the court to determine whether its steward can be withdrawn from the ACC, unquote. That's a classic request for an advisory opinion. And then to make matters worse, if you look at the wherefore clauses at the end of each of the 7 counts in the complaint, they say that the withdrawal payment, and they want the withdrawal payment and the grant of rights to be declared unenforceable so that, quote, in the event and upon a duly authorized affirmative vote by the Board of Trustees, they can be deemed to have given notice of withdrawing from the ACC effective August 14th, 2023, more than 8 months ago. So not only do they want you to declare contractual provisions that they're not yet subject to be unenforceable, but they also want you to grant them retroactive relief, having provided notice of withdrawing from the conference more than 8 months ago. That's contingent on some future action, a vote by the Board of Trustees, that even they allege may or may not happen. You simply, Your Honor, do not have the authority to do that. For more than 70 years, the law in Florida has been that courts cannot grant declaratory relief for the purpose of giving legal advice or to answer questions based on contingencies. Nor can a court issue an opinion about a provision in a contract that's based on a set of facts that has not yet arisen. That is exactly what Florida State is asking you to do here, and the entire amended complaint should be dismissed because none of its claims are right.
In one point of your motion, I think I can resolve what appears to be inconsistency in your position. And I understand this, and in a minute I want to hear FSU's response, but in another portion of your motion, excuse me if I can't give you the exact point, but I think you'll know, there's an argument that's made that FSU in every count is asking this court to deem them to have withdrawn effective as of a certain date. I think it might be January or June 24, but I'm not sure without looking at my notes.
At the end of each of the 7 counts, in their request for relief, they ask the court that if you determine that the withdrawal payment and the grant of rights are unenforceable for any of the number of reasons they claim they are, then they're asking that you also declare that they gave their notice to withdraw 8 months ago in August 2023.
So, okay, so I'm going to be, I want to know from FSU whether they gave their notice or they didn't give their notice. It appears that ACC's arguing they haven't given their notice, but that FSU seems to be alleging that they gave their notice. I think the position ACC's taken is that notice has not been given.
Notice has not been given. Florida State has not alleged that they've given notice. What they've said in their amended complaint is that if you declare the withdrawal payment and the grant of rights unenforceable, then they will go back to their Board of Trustees, who may vote to withdraw or may not vote to withdraw. And then if the Board of Trustees does vote to withdraw, then that deems their notice of withdrawal effective 8 months ago.
Florida State has
They're
not
asking
given
you
their
to grant
notice of
retroactive
withdrawal.
relief that they may not even vote to need.
But
That's an improper request for an advisory opinion. Would you like me to stop now and allow Florida State
Yes,
to respond?
thanks.
Okay. Here.
Anything else?
I'm sorry, I did want to correct one statement that I made, which is that Florida State's president voted to raise the withdrawal payment in 2012. They actually voted no, but they've been aware of the withdrawal payment and the amount since 2012, and that'll get into our argument on the statute of limitations
Okay.
later.
All right, thank you. So FSU, well, let me see if I can summarize how I understand ACC's argument, and this is me taking their motion. And it could be, I'm trying to keep it short, so it could be that I've left something out, and when they come back, I'll ask them to point out if I missed something. But this is not my opinion. This is what my summary of what I'm hearing from ACC is that FSU has argued that it has not withdrawn from the ACC, and that the complaint here, the amended complaint, I typed this pretty fast. The amended complaint only seeks guidance from the court to enable FSU to decide whether it should withdraw from the conference. ACC contends that that is an impermissible advisory opinion. Therefore, it argues there is no bona fide actual present practical need for the declaration in the DEC action portion. of the case or DEC action like causes of action. Since a declaration must deal only with a present, ascertained, or ascertainable state of facts or present controversy as to a state of facts. And I kind of don't really know where FSU's position is on that, although I've read FSU's position. So,
Your Honor,
the floor back to you.
Peter Rush on behalf of the FSU board. The answer to that is, I think you correctly stated, at least in my interpretation, of what the ACC is arguing. The mistake they're making, Your Honor, is they use the word guidance, and that is a word we put in our pleading. But what we're here asking you for today, Judge, is a declaratory judgment to interpret contract terms that are in dispute. And those contract terms are in dispute in 2 different courts, maybe 3. That's a concrete dispute. It's happening now, and we want you to resolve the construction issues. The sooner you do it, the sooner this matter is over. And that's the first thing I want to address.
But can I ask you this?
Yes.
In the ACC action that was filed in North Carolina, is there, I think that complaint was amended in January.
It was, Your Honor.
Is there a DEC action to interpret various provisions of the grant of rights and the Constitution as it relates to the issues we're discussing in the FSU case?
Specifically, Your Honor, there is only a declaration with regard to the grant of rights.
Grant of rights?
They've left the ACC Constitution and bylaws out of it.
Okay, and what you're saying here is the issue of whether FSU has decided to withdraw from the ACC is not the issue I should be looking at, but that the present current state of facts is that there is now a disagreement between FSU and ACC on the meaning of these various provisions that are mentioned in your complaint.
That is exactly right.
Hold on, let me write that down.
Yes.
Because by the end of the day, I may not recall that. But I'm not saying it's going to take all day, but I mean by the end of this. Okay, sorry to take that time, but I'm trying to get these notes.
No, Your Honor, I think it actually plays directly into what I'm about to say in 1 minute.
All right, go ahead, Mr.
But
Rush.
let me first address the statement. They corrected it. Ms. Nunnally corrected the statement. With regard to the increase in the withdrawal penalty, that's in the contract, which is the ACC Constitution and bylaws. Not only did Florida State vote against it, they fought like a lion to stop it. And I want to quote what is widely reported in the press, the comments of the board chair of the state entity of Florida with regard to that increase, Your Honor. These are his words, Chairman Benz, not mine. 2012.
Who was that?
Chairman Benz.
Okay.
Fallon Benz.
The legislator,
Yes.
former legislator? Okay, now I know who you're talking about.
Quote, President Barron voted against it. I personally think that $50 million is punitive. I am not sure it holds up. If $50 million is punitive and does not hold up, then what's $140 million? But let me,
I want to say this. I've read the complaint multiple times. I've read the motions multiple times. I am aware, I'm not saying those facts are not in the complaint.
understood.
But I
They're
am
not.
aware that there will be some facts given to me that are outside the complaint. And I'm doing my best to separate the facts in the complaint versus the outside. And I know that from a standpoint of argument that context is important. And I'm not going to, the lawyers are good. I'm not going to try to limit the lawyers, but motion to dismiss standard, and I'm going to keep going back to this, is I'm bound by, well, I didn't write this down because I hear it every day when I hear other motions to dismiss. I'm bound by the allegations contained in the four corners of the complaint. There are some exceptions to that, particularly with regard to the jurisdictional issues, but generally I'm required to go within the four corners of the complaint. I must treat the factual allegations of the complaint as true and consider them in the light most favorable to the plaintiff. The test for a motion to dismiss is that a complaint should not be dismissed for failure to state a cause of action unless the movement can establish beyond any doubt that the claimant could prove no set of facts whatever in support of his claim. That's not my writing. That's from Ingalsby versus Stewart Agency, 869 Southern 2nd 30, Florida, 4th TCA 2004. The only reason I say that is I want for us to remember that's what I am here today. I do believe that context is important in any oral presentation, but I want to remind everybody in the room, it's not my job today to decide who is right and who is wrong. It doesn't mean I haven't heard the evidence yet. It reminds me of a story. Some people think it's true, some people think it's not true. After opening statement, the judge took a break and the jury came back and says, we've reached a verdict. And the judge says, sorry, but you haven't heard any evidence yet. So I'm sort of at that stage. I haven't heard any evidence.
You have not, Your Honor. The only reason I dovetail into that is that the argument is the withdrawal penalty is supportable because we voted for it. The answer to that's factually wrong.
I understand.
So I won't go any further.
I don't want to really limit either side in what they say because it's their call on what they say, but I'm going to try to keep in my mind what's in the complaint and what isn't.
Understood. I would ask nothing else. And
okay.
You also know under Inglesby, you stated the correct standard. Under Haskell, you're to resolve all reasonable inferences in favor of the plaintiff with regard to the allegations. And I'd like you to focus on that for this next part of the discussion.
Yeah, I'm aware of that, and that's why I said earlier that when you consider the allegations in the light most favorable to the plaintiff, that, in my opinion, is directed to consider all reasonable inferences in favor of the plaintiff at the motion to dismiss stage. But after that, it stops.
Agreed. Agreed, Your Honor. So with respect to that question, back to the ripeness question, we have alleged, and it's in the complaint and it's in the motions, that under that contract, and that's one of the three contracts I'm going to address, under that contract, the ACC has committed multiple material breaches before we have withdrawn. The breaches preceded it. Under undisputed Florida law, a material breach of a contract relieves the offended party from performing any further duties under that contract. We seek a declaratory judgment in this action today that these material breaches relieve the FSU board of any and all obligations to comply with any part of the withdrawal provision penalty in that contract. That's ripe. That's today. The breaches are historical.
Okay.
Your Honor noted last week that the FSU board doesn't seek any damages. It just seeks contract construction, and that's the truth. The FSU board merely seeks to exit the Republic, leaving the ACC and all its members intact as they go. That's why we provided last week, Your Honor, the January 24, 2024 letter exchanges between the top lawyer in the ACC and the top lawyer of the FSU board. Though litigation was pending, Ms. Egan's letter of January 18th proposed 3 positive paths to reconciliation.
Whoa!
So let me ask this.
Whoa!
That means there's settlement discussions in these letters. Is there any objection to me considering that from either side?
Not on our behalf.
Whoa!
Your Honor, I don't want to set up a system in which we've waived the ability to speak.
But you did ask me to take judicial.
No, they asked you to take.
Well, you agreed with their request for me to take judicial notice. I just want to make sure we have a clear record.
Correct, and I don't believe it's being offered for an improper purpose.
Okay.
He's not offering it to show the fact of any discussions. I think he's offering it for something different, as I understand you.
I am, Your Honor.
All right. Okay.
Ms. Nunnally began with a comment that I could not agree with more. This case is actually simple. And based on the hearing 2 weeks ago, it's become even more so. What Ms. Nunnally got wrong is that there are 3 agreements. She got 2 of them.
The third being the ESPN agreement?
agreement. Now, when Ms. Egan wrote her January 18th letter to Ms. Hoke, she had no idea that the ACC had secretly gathered the other representatives of the Republic to propose amending the ACC's pleading to add $100 million damage claims to their case in North Carolina.
So North Carolina seeks damages in its case?
When you add up the amounts, yes, they have a damage claim.
Okay.
And we are told, but not shown, that during the Ides of January, a supermajority of our gathered ACC brethren drew their daggers on us.
Dagger. Dagger. Dagger.
That's hardly the harbinger of happy future family gatherings of such a republic. I'm not aware of any athletic conference that has, in 3 different instances, initiated damage lawsuits against its own members for tens, if not hundreds of millions of dollars. Only FSU was left out of the meeting.
Clemson invited?
They were invited, but apparently, and this is outside the record because I don't know, they claim they did not attend.
All right.
But the FSU board didn't retaliate when it amended its complaint 3 days or 11 days later. It still stands here today, like it did in December, asking this court to construe a small handful of dispositive contract terms. For if it does, the FSU board maintains all else will fall into place. There are 3 contracts, Judge.
We got fireworks this morning. Already we got fireworks.
They are the ESPN agreement, The ACC Constitution and bylaws, and the grant of rights. John, if you could share those.
Yes.
One of the fireworks, there was letters sent from the top lawyer of the ACC to Florida State in regards
Now, you will
to
note
settlement.
the ACC has all these agreements, but you'll note that the ones you and I have, the ESPN agreement is blank for pages 1 through 160. But that's an issue for discovery. The second document is the ACC Constitution and bylaws. And I will note, Your Honor, as I point to those two, that neither one of them mention the grant of rights. Neither one of them capture any terms from the grant of rights. So if the grant of rights was so important, why aren't they in there? So let's start with the grant of rights, Your Honor. And by the way, we requested the ESPN agreement 2.5 months ago. The Florida Attorney General demanded the ESPN agreement 3.5 months ago. And this is what we have.
To your knowledge, do you know if there are any pending in either state? In Florida, we would call those 119 suits or public record suits on any issue in this case?
No.
I don't know of any, and
Okay.
the ACC does not either. But that's an issue I would like to get to later, because I have a proposed solution, Your Honor.
Oh. Okay. That sounds ominous.
It doesn't, Your Honor. It actually...
Your Honor, we're at the first part of the hearing where we're talking about the initial issue.
I don't want to get into the discovery. They have the right to address this.
He's correct. He's just saying, let's try not to turn this into a marathon if possible. See if I can read between the lines. I agree with him. But go ahead.
Okay, so now, the
I want to rush you.
The focus here is on the third agreement, the grant of rights, Your Honor. And candidly, there's only 2 provisions in it that you need to construe. The first, Your Honor, is subsection 6Y, and I've highlighted it. This agreement's only 3.5 pages long. You could read it over a cup of coffee, as compared to the ACC Constitution and bylaws and the ESPN agreement, which is 160 pages. But this is the provision. Why? Now, what Ms. Nunnally said was that we are here to destroy the grant of rights agreement, that we are here to declare it invalid and unenforceable. And I'm telling you today we're not. 6Y says it will not take, that FSU will not take any action or permit any action to be taken by others subject to its control, including licensees, or fail to take any action that would affect the validity and enforcement of the rights granted to the conference under this agreement. Now, you were told 7 times on the 22nd, or the 2nd, the 9th, I apologize, that was a covenant not to sue, but you know that it's not, and you know that this is not a settlement agreement. So what is it? It is, at best, a covenant not to challenge the validity or enforcement, not to claim the grant of rights is invalid and not enforceable. Now, Your Honor, I'm going to ask you for this purpose of this argument to set aside the following questions. Whether or not the FSU board ever approved this, and whether or not a covenant so written like this can ever withstand Florida Constitution, Article 1, Section 21, access to courts, which says the courts shall be open to every person for redress of any injury, and justice shall be administered without sale, denial, or
Do you have
delay.
anything else on the ripeness argument? Because this is important, and I want to hear it, but I don't think it's ripeness.
Yeah, I'm going to get to that if I can. This is how it is ripe right now.
Okay.
Okay?
All right. I
All
got
right.
you.
So, the action we are taking here today you are not required to declare the grant of rights unenforceable. You're not required to declare it invalid. All you're asked to do is to interpret it. And for that, Your Honor, I would take you back to paragraph 1. The front page, Your Honor, I'm sorry.
Okay.
The fourth recital, whereas, has ESPN agreement highlighted in blue. That's basically the composite of all ESPN agreements. The operative provision of this grant of rights appears on the next page, and it's aptly 1A, and it's aptly named grant of rights.
What page am I on?
You're on page 2, Your Honor. It's highlighted in yellow.
Okay.
Let's read that language. Each of the member institutions hereby irrevocably and exclusively grants to the conference during the term, as defined below, all rights, the rights, necessary for the conference to perform the contractual obligations of the conference expressly set forth in the ESPN agreements, regardless whether such member institution remains a member of the conference during the entirety of the term. Now, I know the first question you have, Your Honor, you see that the ESPN agreement is highlighted there 7 times, 8 times, and you don't have that, neither do I. But that's not a problem today. Why? Because at the hearing last week, we learned the following, and I quote from page 144, lines 18 through 22 of the April 9th transcript in this court. Quote, there's a broadcast of Florida State's games for which they're paying them money by ESPN. This is the ACC lawyer. The problem is ESPN doesn't have rights to broadcast anything. Once Florida State leaves the conference holds those rights. At page 145, line 5 and 6, the ACC lawyers say, yes, but ESPN has no right whatsoever to broadcast that game once Florida State leaves.
And I said that
what that means, Your Honor, is those games that Florida State plays after its leave are not necessary for the conference to perform the ESPN agreements.
Huge
because
mistake.
If they were, ESPN would have rights to them.
Huge mistake by the ACC lawyer.
Stated even more simply,
huge.
Because the ESPN agreement fails to encompass the FSU games, home games, after FSU leaves, then the ACC can obtain no greater rights under the grant of rights than those that ESPN has. Why? Because this grant of rights is derivative of the rights in the ESPN agreement. It is no greater and can be no greater. So the rights transferred by the FSU board, assuming they did, were only those necessary to perform the ESPN agreement. And in the words of the ACC lawyers, they aren't. Quote, once Florida State leaves the conference holds those rights. Quote, but ESPN has no right whatsoever to broadcast that game once Florida State leaves.
And they should.
And Your Honor, I'm going to take you now to page 146, lines 10 through 14 of that transcript. That world doesn't change simply because the rights have reverted from ESPN to the ACC because Florida's left, unless ESPN wants to continue to pay for those rights. Then the world doesn't change there either. And they go on. At page 144, lines 25 through 145, lines 10, the conference could broadcast it. The conference can go with Florida State. They could hire someone to broadcast. They could sell those rights. They could sell them game by game. They could sell them back to Florida State. But ESPN has no right whatsoever to broadcast that game once Florida State leaves. The conference still holds the right. And if the ESPN does broadcast that game, by God, they're going to pay for it. And then the money will be shared the way it always has been shared. Bottom line, Judge, as we sit here today, under the ACC's own interpretation, the ESPN agreement does not extend to the home games that Florida State plays after it leaves.
Yes.
That's the construction we would like. And we think it's a construction that can be done now.
It was a terrible mistake by the ACC lawyer at April 9th. And we screamed when he said that.
Regardless of whether the conference, regardless of whether such member institution remains a member of the conference during that term. And that's why this is immediate. That's why it's concrete. That's why it's today. It needs to be done. This is beneficial. Continued litigation is beneficial to no one. It does not further anyone's needs. This is what the contract says. We merely ask that it be construed. But that clause, Your Honor, I'm going to cross-reference and describe it as the choke it dope clause. What do I mean by that? What that means that if should next fall a game be played here in Leon County in which the choke it dope occurs again, choke it dope 2, I'll call that. That means that if Florida State University leaves the ACC at the end of next year, the year after, whenever, ESPN owns choke it dope 2 forever, in perpetuity. And that only makes sense. They paid for it, they own it, it's theirs. So,
well,
Your Honor,
until 2036, maybe.
Maybe until 20. That I've thought about that. I don't have an answer for you on that. But this way, Your Honor, this construction, just bear with me one moment longer.
Because if we don't do this, we're not going to get past ripeness.
I know. This leaves the grant of rights intact. This does not declare it invalid. It does not declare it unenforceable. It just reads it for what it says. And Your Honor, if that's done, then this entire dispute comes down to a one-trick pony, and that's the withdrawal penalty. And personally, I'm confident that the parties can mediate a settlement on the withdrawal penalty
Mediate.
in fairly short order.
So you say you don't want me you're pulling me into this argument, so I've got to ask you this one question.
You should have a voice.
You don't want me to enforce or change or do anything to the grant of rights other than to interpret it.
I am asking.
If I interpret that the grant of rights calls for $500 million as the purchase price for FSU to buy it, you want me to leave that alone and do nothing? Because I don't think that's what your amended complaint says.
No, it is not, Your Honor. You're required to draw all inferences in favor of us today on this motion to dismiss.
I know, but aren't you asking in your amended complaint that I treat that as an unenforceable penalty?
Oh, yes, Your Honor.
So you want me to do more than just interpret it. You want me to interpret it, then if it goes your way, you want me to change it.
No, I don't want you to change it. All you need to do is declare it an unenforceable penalty. But that's the distinction, Your Honor. 6Y that we read only deals with the grant of rights. I would agree that with regard to this contract, we are saying that the withdrawal penalty...
This contract being the ACC manual.
Correct.
For the record.
We are saying this contract, we are maintaining that. I'm not abandoning that. I was a clerk for a federal court trial judge, and my job was to find solutions. This is a solution whereby you don't have to break a lot of glass.
Oh, I'm going to give everybody a chance to find
I understand
solutions in about 90 days.
I want you to.
Just so you'll know.
90 days.
But, Your Honor,
90 days
yes,
solution.
To answer your simple question, we are seeking to invalidate the withdrawal penalty that is in this paragraph.
We're way ahead of the rightness column right now.
No, but that's what I'm saying. What is ripe on that, the withdrawal penalty, Your Honor, is that we want a declaration that there's been a material breach and we're relieved.
You know, do you need a break? Are you good? You tell me when you... Does anybody need a break before we go to the... My next thing I've got is probably personal jurisdiction.
Thank you, Your Honor.
All right, thank you, Mr. Rush.
Holy smokes.
Does anyone want to take a break before we delve into personal
take a
jurisdiction?
break.
I'm fine, Your Honor.
Let me ask the court reporter. It's not as short as rightness.
Okay, while we wait for this to pop up again, holy smokes, couple things. One is the lawyer for ACC, Amy, I believe her name is, made an unforced error when she talked about how Florida State did vote for the higher level of exit fee in the 2012 vote in the ACC bylaws. It turns out that she had to correct her own mistake, and then the Florida State lawyer jumped on that. Second point is that the Florida State lawyer was bringing up letters, and those letters have been given to the judge. Letters between the ACC top lawyer, that's how the Florida State lawyer described, the ACC top lawyer to the Florida State, and he said the word settlement, and then the discussion went pear-shaped, it went somewhere else. But the Florida State lawyer kind of, I believed, let me know what you think in the chat room and with the phone calls later, it seemed to me that the Florida State lawyer leaked out there in public that there had been at least some sort of letters from the ACC top lawyer talking about 3 options of a settlement. 3 options of some type of settlement. That's what I got out of it. It was a very quick very quick discussion that the Florida State lawyers seem to want to leak there early in the discussions. The big one is the Florida State lawyer accurately putting out what the ACC lawyer said April 9th, Leon County. We caught it at the time it happened. I screamed in the microphone. I got yelled at by people in the chat telling me to shut up, but I was screaming because the Florida State lawyer basically, the ACC lawyer basically was saying, trying to explain to Judge Cooper that if Florida State would leave the conference, ESPN would not have the rights to distribute Florida State's home games. It would go back to the rights of the ACC. That Florida State, that the ESPN would no longer be the content holder, the one that distributes Florida State's home games, which makes the grant of rights play like a violin, Beethoven for Florida State. It makes it look like that Florida State is no longer attached to the grant of rights simply by saying they're not part of the conference because the Gore and the media. That was a huge mistake by the ACC lawyer. I don't know if he's correct. I don't know if he's correct about how he's interpreting the ACC ESPN media rights agreement. But if he is, if the ACC lawyer let it slip out that ESPN suddenly is not part of any Florida State's distribution of their content, the moment that Florida State walks out of the conference, then the whole grant of rights collapses, because in the grant of rights it said only that is necessary. Florida State and other ACC institutions would give their rights, their media rights to the ACC only when it's necessary to fulfill ESPN, the obligations to ESPN. But in that media rights agreement, if it says, hey, ESPN doesn't do any more Florida State games the moment Florida State is out of the conference, that alleviates Florida State from the grant of rights. That means they get their rights back. Same argument that Clemson's making. My point is, and then so the Florida State lawyer picked that up off the transcripts. I think they knew it at the time that the ACC completely screwed up. That lawyer on April 9th completely screwed up when he said that. Anyways, okay, let's see if there's any other. Hopefully we'll get this back. Keep an eye out for it. I'm going to open up the phone lines. Remarkable fireworks this morning. Florida State lawyer jumping on the ACC's lawyer's mistake of April 9th. Settlement. There was some letters about settlement, 3 different options of settlement from the ACC's top lawyer to Florida State. January 24th, and the emails, letters, and the lawyer of Florida State gave that to Judge Cooper. They gave it to him on Friday. It looks like he didn't read it. They gave it to today in the court. Let me know if you've got the same interpretation on that. We're going to open up the phone lines right now. Keep your head on a swivel. Let me know when the live feed comes up again. 763-260-1333. 763-260-1333. Give me a call. Let me know if you believe I got it all wrong. Let me know if you believe I got it all wrong But I think the Florida State, jumping all over what the ACC lawyers said on April 9th, I tell you, woo! Let me know if the live feed is up. Let me know when the live feed is up. Give me a call, 763-260-1333. Holy smokes. Phone lines are open, 763-260-1333. Unbelievable.
Call from
Crab cakes and football.
Crab cakes and football. What are you thinking here? As we wait for a live feed to pop up again, what are you thinking?
I got two thoughts. First, a double no, betraying the no nation by being the lawyer for the ACC. I just thought that was funny. And then the second is the first one that made a mistake is going to lose, and I think the ACC made their mistake. I think even if this record can be pulled up and used in North Carolina, even if North Carolina got it. So I think that the first one to make a big mistake is the one that was probably going to lose at the end, and I think the ACC just did that because, I mean, I'm not a lawyer. I'm just a truck driver that hauls freight every day, but even I know that if another vehicle makes a mistake, they're going to have an accident. So, you know, it's just one of those things. So, I think the ACC probably – they didn't dig their hole, but I think they put the first couple of swipes out of the ground and start making their pile for their hole.
Either the ACC lawyer on April 9th misspoke, misinterpreted what's really in that ACC ESPN agreement, which was a big folly, or he did not misinterpret it. He actually told the truth, and holy smokes, did the ACC screw up on that media agreement in the language. We did a live show on Saturday night. Crab Cakes and Football. We talked about what we have come to know as the Texas SEC agreement, membership obligations. That language, if that language in there mirrors what is actually in the ACC ESPN media agreement, the ACC they need to start negotiating because they're in trouble. Go ahead and finish your call. We've probably got more calls coming.
ESPN is going to have the same agreement for all of their all of these conferences.
Yep.
So if the SEC's agreement is going to be the same as any Big 12, it's going to be the same as the ACC. Numbers might be a little bit different, but that's nor here nor there. But I mean, there's going to be, so if they have that same language in there for them to sign, and there's a loophole that wasn't detected before, or a screw up in there that wasn't detected before that's been found out, this is where a judge comes in to rule, and I think that's where we're going with this.
Yeah.
I mean, they do have the issue that, yes, FSU signed a contract, and their board regents and the president or whoever signed a contract. Okay, that's the issue they had. They did sign it. But at the same time, if there's this loophole that, hey, it doesn't matter about the grant of rights because once they opt out of the ACC and they pay this money and they leave, then they're gone, and then it stops there, and it remains to the ACC. So I think this has to go to settlement now. I mean, I've always said that from the beginning, just like everybody else. But I mean, the more I watch and learn and just see and everything because of how business law goes and how this is going, it just seems like, even in the North Carolina case where, Judge Bledsoe, I think his name is, he's clearly, he's going to rule for the ACC. Even he had a couple of questions about that. And then now you've come over to Florida State, Florida, which is clearly going to rule for Florida State. They're popping up questions about that. So I think they found the anchor that's either going to hold the ship or sink the ship.
Yep.
So
that's
where I think this is going.
I appreciate the call. Crab Cakes and Football. Beautiful, sir. Beautiful.
Have a good one. All right. Bye.
You too. Thank you. Again, let me know if on ABC 27, WCTV, let me know when we get a live stream back. Look, in my mind, there's already been fireworks that I was not expecting. Great call. Let me know. Kerry Gold knows. This was a while ago. Greg, ABC 27. ABC 27. Let me know in the chat if it is, if they do have a live feed on that, and I will go to it. Let me know. David Hackett, good morning, Greg. Today is definitely going to be a Florida State day. Wow. Everything from the Florida State lawyer leaking a little bit there that there had been an attempt by the ACC top lawyer to start talking settlement. And then them jumping on ACC's lawyer mistake of April 9th, talking about how ESPN would no longer have any rights to distribute Florida State's games. Well, then that means that Florida State, under the grant of rights, Florida State would not have any more obligations to be part of the grant of rights because it said in the Gore, necessary. Florida State, any ACC institution would give their, all their media rights, everything to the ACC for what it is necessary for the ESPN media rights. And if ESPN doesn't have those rights anymore.
Call from
JD.
JD, the floor is yours. Let me know anybody once we get some live stream somewhere. Let me know in the chat or on Twitter. Go ahead, JD. The floor is yours.
Your Honor.
Hey, sir. So we don't sound like a delusional fan base.
It's up. JD, you can call me back later.
He's fine.
Yes, sir.
Okay.
We
I
actually,
apologize,
we
sir.
accept Florida State's argument
you're
in
good,
response to
you're
our
good.
motion to
All right,
dismiss, and we concede that if this action were properly in front of you right now to proceed forward, that venue would be appropriate in Leon County. So we can check that one off the list.
Okay, hold on a minute. Okay. All right.
And if Your Honor would allow, if I could just make two quick points in response to the ripeness argument.
Certainly.
Thank you. You are exactly right when you talked about this being a sufficiency issue. Ripeness raises the question of the sufficiency of the pleading. I know that we heard a lot delving into the different provisions of contracts, that some of which are not actually relevant here, and some other issues about the merits of the Florida State's claims. But the question that we raise in our ripeness argument is whether the amended complaint as it stands right now is a sufficient pleading, and it's not, because none of the claims in the complaint are ripe for adjudication. The withdrawal payment, Florida State did not argue to you today that it has provided notice to the ACC that it is withdrawing. That is the fact that matters for a determination about whether their claim is right. There is no reasonable inference that can be drawn in their favor in the amended complaint that they have voted, that the board has voted to withdraw from the ACC. For that reason alone, any of the claims in the amended complaint about the withdrawal payment are not ripe, and they have to be dismissed. And then on the grant of rights, all of the discussion that Mr. Rush went through regarding the grant of rights is way beyond what's alleged in their amended complaint about the grant of rights. And so, again, as alleged in the amended complaint, any claims that they may have about the grant of rights are not ripe, and we would also ask that those be dismissed for that reason.
All right.
So on personal jurisdiction, we're also looking at the sufficiency of the complaint, and the complaint is deficient on its face with regard to personal jurisdiction. To satisfy the pleading requirement to establish jurisdiction over a non-resident defendant like the ACC, FSU was required to either plead the provision of the long-arm statute that it claims applies to establish personal jurisdiction, or to plead facts sufficient to show that personal jurisdiction exists under the long-arm statute. But they didn't do either of those things. In paragraph 4 of the amended complaint, where they attempt to plead personal jurisdiction, they have one sentence which says, because the ACC is a citizen of every jurisdiction in which its members are citizens, and 2 ACC members are Florida citizens, the court has personal jurisdiction. That's it. That's their personal jurisdiction allegation. But I don't think anyone can dispute that that allegation does not track the language of the long-arm statute in section 48.193, and it's just also incorrect as a matter of law. What they have pled in paragraph 4 is actually the test for diversity of citizenship, which is a subject matter jurisdiction test in federal court. That's irrelevant to the issue of personal jurisdiction under Florida's long-arm statute, and we cited several cases in our motion to dismiss that all stand for the proposition that state courts do not apply federal subject matter diversity of citizenship principles to establish long-arm jurisdiction. In response to that argument, Florida State essentially says that it shouldn't have to replead and actually identify its jurisdictional basis because there's some facts that are pledged throughout the amended complaint that, in their view, not ours, show that it could have alleged personal jurisdiction under the long-arm statute if it had attempted to do so.
So can I ask you, I know you know this case, the Venetian Salami Company
Yes.
case?
Yes.
1989 case, and also the Belts versus Grupo case, 1998, 3rd DCA. As I read the pleading requirements in Venetian and Belts, Venetian says there's 2 steps. One, I must determine that the complaint alleges sufficient facts to bring it within the ambit of 48.193(1), and then there's a bunch of subdivisions after that. And Belt, as I read it, says to meet the first prong of the salami test, there is no requirement to track the language of the statute, but merely to set forth facts. This is in quotes, facts to fit within one or more of its subsections. So, am I looking for 48.1931A1, or am I looking for facts which would meet some particular section of 48.193 is the long-arm statute, facts that fit within the long-arm statute?
I think what the Venetian Salami case says, Your Honor, is that you can do either or. There's a lot of case law after the Venetian Salami case that says if you track the language of the statute and you identify which provision under subparagraph 1 you're traveling under, that's sufficient.
That's enough.
That's enough. If you don't do that, then you may also be able to meet the pleading requirement by pleading sufficient facts to show which provision of the long-arm statute that you're traveling under. And our point here is that Florida State didn't do either of those things. Generally, in a complaint, when you're pleading jurisdiction, in the section of your complaint regarding personal jurisdiction, if you're not going to track the long-arm statute, which they clearly did not do here, then you would identify the jurisdictional allegations that would bring the defendant under the long-arm statute, that would bring them in under the long-arm statute. But instead, in response to our argument, Florida State says that you can go throughout their complaint and pick out a few allegations here and there that they say would establish personal jurisdiction under, I think it's section 1A1, and that's enough.
Right.
But that's not enough, Your Honor. They are asking for us to identify which jurisdictional allegations satisfy the long-arm statute. That's not the law. They're required to plead specifically jurisdictional allegations.
If the complaint states facts to show that the ACC was operating, conducting, engaging in, or carrying on a business or business venture in this state, or having an office or agency in this state, is that enough, even if they don't say those words, don't mention the statute number? Yes, it'd be helpful if somebody had mentioned the statute number and said those words, but
They have to identify them as jurisdictional allegations so that the ACC can then determine whether the burden it has shifted to them to file an affidavit that would dispute the jurisdictional allegations and argue that there is no personal jurisdiction. Our point is that the complaint is insufficient on its face, and the burden has not yet shifted to the ACC because they did not plead sufficient jurisdictional allegations.
there's a case, let me ask you if you're familiar with, I'm going to call it the professional golfer case.
Okay.
Give me a second, I'll give you the Gallant versus German Shepherd.
Mm-hmm.
Just a minute. First District. 4th District. 4th DCA case, 2010. The reason I'm asking you about that case is some people got together and decided to set up I'm going to call it a joint venture to back a professional golfer who was going to play tournaments in Florida and tournaments other places. And there were a number of members, backers, and the fourth DCA. Who was involved in this case? Okay. Fourth DCA at head note 6 at the end of the case said that the club, that's the joint venture, the backers of the professional golfer, the club received pecuniary benefit from its business activity when it received dues from its Florida members. So that may have some applicability to this case. People may differ on that. And receives fees from its associated member clubs in Florida. The club reached out to Florida in the past. Maybe this is not a golfer because it's referring to a dog show. So the golfer case is a different case, obviously, but it said it held a dog show and multiple club meetings in Florida. The club receives advertising revenue from its monthly magazine, which is mailed to club members in Florida. This activity, when considered collectively, shows a general course of business activity in the state for pecuniary benefit. And I'm going to try to find that other case for you, which I think is a first DCA case. Sutton versus Smith. It's the golfer case. It's the first district case. For the record, 603 Southern 2nd, 693, 1992. Judge Seamer wrote it. Okay, that's where they got together. This is the golf club case. They got together, formed a partnership joint venture to sponsor a pro golfer, and he was going to play certain tournaments in Florida. And income he received would be paid into the partnership, and then he would get certain income out. And it said the parties to the agreement, I'm going to call it joint venture, contemplated that substantial activities to further the joint venture would take place in Florida. FSU's alleged here, the plaintiff is alleged here, that the members of the ACC contemplated that there would be substantial activities to further the joint venture, home games in Florida. I know there are home games which might be outside of Florida, but most of them are in Florida. Sutton lived in Florida. That's the golfer. And he was expected to and did play tour events in Florida, just like FSU was expected to play home games in Florida. The partnership dispersed funds from the partnership account to Sutton's bank account to enable him to perform golf-related activities and participate in tour events for the benefit of the joint venture. And Sutton agreed to transfer compensation received from golf-related activities to the partnership for the benefit of the joint venture. And it says these undisputed facts place the joint business venture within the ambit of 48.1931A. Now it may be 1A1, I don't recall. I think they renumbered the statute. But it's the same statute. As they show that the members of the joint venture were operating, conducting, engaging in, or carrying on a business venture in Florida. So I guess the question is FSU required get my copy of the statute. Is FSU required to say that, or are they required to say facts which would lead to that, which support that conclusion? So I'm going to I've stopped talking now. I'm going to turn it back over to you.
So, Your Honor, I think again, we're looking at the sufficiency of Florida State's complaint. The analysis that we just walked through in the two cases that you cited, you would only get to if they had sufficiently pled personal jurisdiction. Once they've made sufficient allegations, then we can get into the question of whether they actually meet the test. They've actually pled facts that would establish personal jurisdiction. We haven't even gotten that far yet because their complaint is deficient. They don't identify which provision of the long-arm statute in the complaint. Now, I know they come back in response and say we're traveling under 1A1, but that's not in the complaint. And the test here is the amended complaint, and are the allegations in the complaint as pled sufficient? They're not. For jurisdiction, for personal jurisdiction, they're just not sufficient. Having to pick out facts throughout different parts of the complaint that aren't identified as jurisdictional facts, that's not sufficient.
Is there a case that says they have to say the statute name and that only that will be sufficient?
No, and we're not saying that's a requirement, that they have to say the statute, but there has to be a section within their complaint that includes jurisdictional allegations. And in the amended complaint, we have one jurisdictional allegation. That's not the correct test for personal jurisdiction. They're relying on subject matter jurisdiction in federal court, the diversity of citizenship. And so that's what the ACC is looking at as their allegation regarding personal jurisdiction. And that test, their incorrect test that they've pled, the incorrect the facts in that part of the complaint are not sufficient to establish personal jurisdiction. We then shouldn't have to go beyond the single incorrect allegation regarding personal jurisdiction to look for other facts throughout the complaint that may actually establish personal jurisdiction. They need to properly plead it.
Granted, it would be better to have stated it in a section that says jurisdiction and venue, but is there a requirement that says that they must endorse?
I will be back in a couple of minutes.
Versus Group O.
I'm going to leave the studio for a couple of minutes.
Within one or more of the subsections of 48.193. Is that required to be stated in a concise or specific section of the complaint labeled jurisdiction?
The Venetian Salami case, which is the seminal case on this topic, it doesn't say that explicitly. However, the allegation that they do have in the jurisdictional section of their complaint does not establish personal jurisdiction because it's not an allegation that's based on any provision of the long-arm statute. That's where the deficiency comes in, Your Honor.
But don't they allege facts in other portions of the complaint that do it sufficiently allege, if proven, a business venture in this state? That's the reason I cited the golf case, because it seems quite similar to me, that show that ACC's conducting, ACC and FSU together with other universities are conducting a joint venture, carrying on a business really in multiple states, but as it relates to this case, in the state of Florida, because it is deriving revenue from home games in Florida. It has set up an ACC network which broadcasts games and other ACC sports from Florida or that occur in Florida. It derives revenue from home games in Florida, and it dispenses revenue back or funds back to FSU, which is a member in Florida. And in one of those cases, either the dog case or the golf case talk about the members, wherever the members of that venture live, those are, quote, offices of the joint venture. In this case, it's where those universities are. But it's clear that if you look in the complaint, it seems as clear to me that FSU's alleging they're in whatever you want to call it, they're in a joint undertaking with ACC. I would call it a joint venture, but it doesn't have to be called that. That might connote some specific legal terms or requirements, but it's a joint undertaking with ACC to make revenue off football games and theoretically softball, baseball, basketball games that occur in Florida, and to distribute money back to the ACC in Florida for those games. That sounds like operating, conducting, engaging in, and carrying on a business venture in Florida.
Your Honor, we are not prepared to concede today that those allegations that you cited would satisfy the long-arm statute, and the reason is because they have not been properly and sufficiently pled in the amended complaint. It may be possible that if they amend their complaint again, they may sufficiently plead personal jurisdiction, but that's not the standard. The standard is, as the amended complaint currently stands, are their allegations sufficient to put us on notice of which provision of the long-arm statute applies? And the single allegation in the jurisdictional section of their amended complaint is not sufficient. And I won't belabor the point because I understand where you're coming from, Your Honor. So if you...
Well, I mean, Mr. Rushby talked me out of it too, so I don't know, but let me ask you this one thing. Let's assume that they have met the first prong, as I understand this. You might not think we get many jurisdictional cases here, and we have it in the past, but for some reason, I've had several recently. And I've read the Salami case more times than I can recount, not for this case, but for other cases. But if you meet part one, or requirement one, then you go to requirement two to meet what I call the federal due process standards. And that requires, the burden also shifts, doesn't it, to the defendant to provide proof by affidavit?
That's right.
And that's a scenario in which one can, I was mentioning earlier, there are some limited scenarios in which one can go outside the four corners of the complaint. That's one of them, personal jurisdiction.
Right. That's right, Your Honor.
So, okay. Mr. Rush, can you do this in 11 minutes?
I think so, Your Honor.
All right. That's just a tip-off to everybody here. I plan to take lunch in 11 minutes.
Your Honor, you've read the Venetian Salami case the right way, but I don't need to tell you that you have because you already know that. In any event, the facts just need to be anywhere in the complaint. They've not challenged jurisdiction. In fact, I'd like to quote the transcript, page 50, lines 11 through 15, the ACC's attorney 2 weeks ago. Well, because, and I don't mean this other than to say, I don't think North Carolina is a better forum or this court is a better forum. I think North Carolina is a more appropriate forum. This can't be an appropriate forum if there's no personal jurisdiction, Your Honor. And we are contesting personal jurisdiction in the state of North Carolina, and we perfected an appeal on that ground. But getting back to Venetian Salami, the facts just...
For the record, that Ms. Nunnally didn't say that.
No, she did not.
Okay.
But if I can, Your Honor, there is a fact that I did not include in our brief, and I should have in the complaint.
It's one of those facts why that wasn't alleged in your jurisdiction section?
I hate to say it, but I'm afraid it was not.
Okay.
It wasn't in the right section of the complaint, apparently. And it's...
You can point out other parts. I've got the complaint open.
Okay, let's go to paragraph 99. It's page 21.
Okay, 99.
No, it's page 21, paragraph 99.
Okay, I'm there.
Okay,
Amended complaint.
Footnote 4, down at the bottom. Under the ACC's agreements with ESPN, conference members are to receive $1 million each year as reimbursement for the costs incurred by those conference members in connection with broadcasting games. The same notion is repeated in paragraph 127 of the complaint. So that means that the ACC is paying into the state of Florida every year $2 million for production costs to produce its flagship ACC network under its banner, the ACC network.
Do you allege in here, in the complaint or the attachments to the complaint, that the ACC has a right, has media rights to FSU home games? That's in here somewhere, isn't it?
I think it is. They do. I think the grant of rights does say that, current home games while they're a member. I don't know where that allegation is, and I can look for it.
Well, my memory of the complaint is that the essence of the complaint with regard to at least a portion of the complaint is FSU multi-part. FSU botched the negotiation of the media rights with ESPN by giving a company in North Carolina certain media rights that normally would have gone to ESPN in a negotiation. Were those home games or non-home games?
It would include the home games. The only correction I would make is you said FSU botched the negotiations.
Okay,
I think you meant ACC.
Okay, so that's in the complaint.
That is in the complaint.
Okay. And it's also in the complaint that the media rights, tell me if I'm wrong, cover the FSU home games.
That's a true statement, Your Honor.
Okay. And that FSU and that ACC derives revenue from FSU home games, NC State home games, the home games of the members.
That's what's paying for all the attorneys sitting at this table here today.
Well, that's
It is,
assuming
though,
they're
Your Honor,
getting.
yes.
That's assuming they're
Yes.
getting paid. I never assume who's paying or
Understood.
if they're being paid on either side. So, and then FSU gets, ACC collects revenues from its, primarily from its media rights, or are there other fees that member institutions pay?
I think there are other components, but the main driver is the ESPN agreements and the payments provided under them. Under the RACOM agreements, which is the term you're searching for, the North Carolina, as my understanding, the members don't receive those payments. The ACC, I'm sorry, ESPN receives them.
Okay. ESPN, does ESPN, with regard to the others, does ESPN cover home games or all games? This is what is alleged in the complaint on that factor.
ESPN, absent a special agreement, covers only the home games. So, but that means, like if FSU plays Georgia at Georgia, that's going to be under the SEC's deal.
SEC's deal with who? I guess with ESPN.
Well, I guess it's ESPN. Let me pick somebody else.
Let's say FSU plays. What's the team that has the blue artificial turf?
That's Boise State.
Boise State. Let's say they go to Boise State. I don't think they're in any of these conferences we're talking about.
If you assume Boise State is not under an ESPN agreement, then ESPN gets no money out of that.
Or in whatever agreement Boise State has, if any, that's who.
That's where the money would flow to broadcast that game.
So, what if the ACC network broadcast the Boise State game that's in Boise State? If they're permitted to do that, do they get a fee from anyone for that?
You're beyond I probably shouldn't speak on that. You're beyond my capacity. I've never seen the ESPN contract. Colleagues from my office and very, very skilled ones have.
All right. So what I'd like to know, because I've talked up your 11 minutes, so I'm going to give you more. What I'd like to know is ask that you identify for me when we come back from lunch in an hour, those sections of your amended complaint which you contend support the whatever provision of the long-arm statute you say applies here for jurisdiction.
And I think there are two, Judge, just so you can consider them over lunch.
Okay.
It's 48193, Section 1A1, and I also think 1A6 applies as well. That is not something we covered in our briefs, but I believe based on what I know that it would be included as well. So I would think we meet.
I have it right here.
Very well. I suspected you did.
Yeah.
1A6, just 2 minutes. It's causing an injury to persons or property within this state arising out of an act or omission by a defendant outside this state, if at or about the time of the injury, either the defendant was engaged in solicitation or service activities within the state. We would maintain that the ACC network, with its advertising on almost a daily basis inside the state of Florida, would be solicitation. With respect to the concept of service, Your Honor, the ACC has taken, it's very clear that the ACC's position is that they provide many services to FSU and University of Miami, so they would be doing both. And therefore, the injuries alleged in the complaint, which are manyfold, would be injuries caused within the state of Florida, even though they may have occurred outside the state of Florida.
By advertising, that's an injury?
Well, the subsection 16A6A.
16.
So 1A6A. So in other words,
okay.
You follow me?
Okay. 1A6A. Causing injury, etc. If at the time of the injury, either A, the defendant has engaged in solicitation and service activities within the state.
And that's
what injury did they cause?
The injury that they caused is A, restraint of trade, B, breach of contract, C, refusal to allow the FSU to participate in the management of the affairs of the ACC at a time in which FSU is not withdrawn. These are ongoing injuries that are occurring by the day. And they're also, Your Honor, outside the state, creating the impression that the grant of rights actually extends to games after FSU. Do you follow me?
I see where you're headed. I think 1A1 is a lot easier to understand.
I would agree with you on that, Your Honor.
And that's what I would focus on. So did you have any other?
I did not, Your Honor.
Find what complaint sections of the complaint which support your contention that ACC is operating, conducting, engaging in, or carrying on a business or business venture in this state, or having an office or agency in this state. Okay?
Thank you, Your Honor.
See you back. And that will also give defense counsel the chance to, look at that too and be prepared to respond to that also, if you wish to do that. So I'll see everybody back at 12:30. Trust me, we're going to go faster when we get back.
Thank you, Your Honor.
Okay. Ronnie Bell.
Yes, sir.
Wow. Well, we're going to open up. I was watching the whole thing when I was out of the studio listening to it. We're just going to open up the phone line, 763-260-1333. I'm not a lawyer. I'm just giving you my opinion. But I don't know if this could be going any worse for the ACC in Leon County. Bill G, thank you so much. You gifted 5 memberships. Holy smokes. Thank you for your continuous generosity to our show, Bill G, to our channel. Thank you so very much.
Call from
Immaculate.
Immaculate, can you hold on for one moment, please?
Sure.
I'm just trying to get caught up. Thank you, sir. Bill G, thank you so much for your generosity. I do appreciate it. You are hereby officially, once again, knighted cloak and dagger. Thank you so very much. And for those who received a gift membership from Mr. Bill G, please say thank you to him. You are all hereby granted knighted Cloak and Dagger. And that means you can go to our YouTube channel and watch the early P Cloak and Dagger episodes. And also, before we get to Immaculate, I can't wait to hear what he has to say. If you're new to the channel, if you're new to college football's Peek Around the Corner, or if you haven't done so yet, please hit the subscribe button and then open up your notifications, because we can come on live at any time. This is college football's Peek Around the Corner. We cover everything in college football because we love everything in college football. We could be coming up tonight again, midnight. Who knows? We follow, we go where the story goes. So please subscribe, open up your notifications, and smash that like button. Thank you so much, Bill G, for your generosity. I do appreciate it. And just making sure. All right, Immaculate, what's going on, my friend? What is happening? What do you think?
First off, I got a bit of a personal problem. It's only 8:30 here out west.
Ooh.
And we're already dealing with lunch breaks. I just feel like I'm so behind the rest of the world.
Yeah. We came on, so we came on 6 o'clock your time then, because we came on at 8 in the morning.
Yeah,
college football realignment never sleeps, and college football itself never goes to bed, Immaculate. Go ahead, sir. What do you got to say?
Well, I certainly appreciate that you're running your clock on this. So thank you for carrying all of this. In terms of what I'm seeing here, first I'm going to say, I actually think she's done one hell of a job, the attorney for the ACC. Her problem is that she did not have very much ammunition. So it kind of felt like someone who was in like if you've ever seen or watched or heard or whatever I don't want to say a fake case. What do they call that when you're going through a practice? A
debate.
Yeah.
What you're saying.
Like you just have to make an argument for something, and there just really isn't much to it. Like saying that they have no right for jurisdiction there because in the complaint they haven't said that they're leaving yet.
Yeah.
Draw more attention and to get more resources. Putting trees into the ground now is going to have a multi-generational effect.
You're basically telling the judge the fact that you even agreed to hear this was wrong, and so on its face, it's kind of insulting. Especially because some of the other motions that he already denied. I don't really know why they threw her at this. Do you know what was the backstory on? Because the last time there was just the two gentlemen there, and they brought her in for this. Was this her specialty, or did they throw her in here because they basically didn't want to do it themselves? Or?
I know she's a Florida State alum. That's all I know. She's a proud Seminole. That's all I know about her. And in the previous, I don't know who that lawyer, I forget the guy's name, but the lawyer who I believe really screwed up on April 9th when he talked about how, he was looking at the judge, he was looking at the Florida State's lawyers, he was saying, on ESPN, they won't even cover the Florida State home games anymore when Florida State leaves the conference. That lawyer I don't know about, but the other lawyer who was present on April 9th and is there today, he's a former judge and I think a state Supreme Court judge in the state of Florida. So he's considered the big gun. He's like the leader of that, the lawyers there for ACC.
Yeah, there's the guy who a couple times has come up to her as she's up there with like a laptop showing her some things. That's the guy who really didn't do very well in the last hearing. And then the other guy who's sitting off to her left there at the defense bench, he kind of seems like the main guy. Is that who you're saying is the previous judge?
Yeah, I think so. I think he's a previous Supreme Court judge, state of Florida.
Yeah, he definitely seems much more at ease.
Yeah.
But maybe they just wanted to have the Florida State grad there saying, hey, look, this, I don't know, maybe they're trying to answer to the whole, everyone having biases, and here's a Florida State grad saying that they're wrong. I don't know. Like I said, this is a long shot for them to try and get this thing dismissed. And in my opinion, he just ruled. Like, his response to her could be the exact wording that's going to be in the ruling when he denies this motion. I mean, you saw it in her face. You saw it in her body language. And even she said afterwards, I get what you're saying, judges. She was wrapping up. She had done her best.
Yeah.
But
she did make one unforced error early on, but I don't think it has any impact. But she did say at first, she said, the lawyer I'm talking about, ACC's lawyer, Amy, I think her name is, when she said that Florida State did vote for a higher exit fee in 2012, she came back and she corrected herself. Florida State jumped on it. But yeah, she made one unenforced error, but I don't think that has no impact. I don't think on anything what's going on here. But
yeah, and I don't think like someone in chat was like, oh, so she lied. No, I just don't think she knew. Like that was a little while back.
Yeah,
Florida State absolutely with Maryland voted against that growth. I remember that very vividly because it was one of those shocking moments of like they're raising the exit fee to what? Because it was like, in the teens, and then they were raising up to like 50-some million is what the situation was back then. So there was, but that's a small thing. Yeah. But so the folks were saying mock court, moot court. That's exactly what I was thinking. Is that they throw you into a scenario where it's basically an unwinnable scenario, and they want to see how you carry yourself because sometimes that's just what you have to do as a lawyer. You're in a position you really can't win, but you still have to do your damn job and do the absolute best you can. And so she did all right, but that's the whole feel that I had to me. It's like you argue a point really well that's really not winnable. So that was my feelings early on.
Yeah. Doug Rohan, and I kind of picked this up from the judge as well. Doug Rohan, I lost the tweet here. Hope I can find it. Yeah, Doug Rohan, 13 minutes ago says the Florida State ACC litigation. This seems to be the weak point for Florida State litigation. You need to be intimately familiar with every word, every paragraph of your pleadings. What you put in the complaint. If the judge asks you where something is, you or a helper sitting at the table behind you better find that with quickness, especially when the other side is asserting you failed to meet a pleading requirement. Here is some home cooking again. We are going to take a lunch break, and I'm going to let you find that. In other words, he's saying Judge Cooper is sort of helping out the Florida lawyers there because Florida State lawyers, they should have been on top of their pleadings, to know every word, every paragraph of the complaints, the pleadings that you put in the court system. Weeks ago, I got that feeling too, like the judge was saying, kind of like saying, you guys really should know this, but lunch break, I'm going to let you guys have some time to figure it out.
Yeah, it was an interesting little twist. He threw a curveball at the Florida State lawyer, and maybe Florida State lawyer wasn't really prepared to face that today. Maybe just, not that it was terrible, but just kind of like okay, all right, we'll get on that. But I just kind of felt like overall, so much of what was talked about today actually goes beyond what needed to be talked about today. Like I thought this would be over by now. This is just over a motion to dismiss. Talk about another thing to be brought up after that. And I think that's why he's saying, let's get this wrapped up because we got more to do.
Yeah. A couple things, Immaculate. One is, now nobody really is talking about in the chat, since it happened. It happened early on. Nobody has corrected me yet and said, Greg, I think you've got it wrong, which I might have. But it seems to me that the Florida State lawyer said, basically leaked out that there was letters from the top lawyer of the ACC case, their lawyers, to Florida State, talking about different options, 3 options on how to settle this or something to that effect. And then quickly the subject changed. Did you catch that?
Yeah, he brought it up, and then the judge was kind of referring to ACC's almost like this can't be used as evidence, or can't be used in this hearing because it wasn't presented. That's kind of the feeling that I had. Maybe someone could better explain how that actually works in. But it was almost kind of like that wasn't allowed. Like that's not evidence to them thinking like when you see a settlement happening, there's always this legal work into it where it says that this is not accepting guilt. This is not. That's what they're saying, is that them possibly talking about settlement doesn't mean that they're saying that they don't have the strong point in the stand. You know what I'm saying?
Yeah.
Like using that to try to sway the judge that they don't see themselves as having a winning case. I think that's what the problem was. Because the ACC lawyer was basically saying, I think the way he's going with this is like this, and that's okay. And so I think it was just kind of procedural.
And then it said here, Florida man in the chat room, thanks for reminding me of this, but it says, what's judge planning for 90 days? Doesn't this show his hand that he's keeping the case? At some point during this morning, the judge said, well, y'all going to find out something in 90 days. And then he talked about, and then he put out another sentence that had he said something schedule. Like he's letting everybody know this is going to take about 90 days and everyone's going to find out what I think about all this. I think he said that, but I don't know. It happened so quickly, off the cuff. Florida man, did you hear that, Immaculate, when the judge said that, 90 days?
No, I did not.
Okay,
that's what
all right.
About that too, and that almost seems like too long. Like, especially with the North Carolina court ordered to expediency, I have a hard time believing that he's gonna, if he denies this motion today and whatever else they're doing, that we're gonna have 30 days until the next time that this is in that court. I actually believe that to be the case, but we'll see.
What I understand is Judge Cooper's going to make a ruling on the ACC's motion to dismiss.
Yes.
And it sure sounds like, he's going to deny it. And then I think the next ruling is ACC's motion to stay the discovery, to get that thing going. I think that's going to be his second ruling of today, and I think then that's about it for today. Am I correct on that?
That makes sense, and maybe that's kind of where the 90 days comment comes. Maybe that's general amount of time for discovery. I don't know, but as chat's saying, that might be alluding to like a known time of nomenclature for how long you set aside for mediation. I don't know.
Could be.
Like in that industry, it might be like, oh, you generally set aside 90 days, 3 months for a mediation talks. And as a previous mediation lawyer, he would probably be privy to that in a way that
Jack Malley in the chat, they have to allow time for discovery and mediation. Mediation is mandatory in Florida civil cases.
Okay.
So,
is that also the case in North Carolina? Do we know?
I don't know. Does anybody know if that's the case in North Carolina? Stephen McNeely, settlement before August 15th? What is 90 days from, let's see, May 1st, June, July, August. Takes us into early August.
We'll have to find out, but that's interesting. And I think, once these get dismissed, I think that's another window. That's a window when not just the ACC, but ESPN has to look at this and say, hey, we still need, look, tying this back to old things, we still need the CFP to get figured out. We have to know how you're going to build this. Because now they're going to have full rights, including rights to sub-license. They're going to want to know, what do we have to sell? Is it, are we going to 12 teams? Are we going to 14 teams? Are we going to 16 teams? How many games is it going to be? What are we looking to sell to others? What are we keeping ourselves? So ESPN now has some skin in the game to get this taken care of. I don't know if people realize that, or maybe they just don't believe that to be true. But there's already talk about the CFP starting to meet again to talk about 2026.
Yeah.
I didn't think that was going to happen until after football, after the season, but they're already talking about doing it now, so that's pressure.
Mm-hmm.
So what he's saying, mediation time, settlement time, with them not getting the motion to dismiss, that would have made it much easier for the ACC, and it would have given them a better, strong position at the settlement table. They might just have to be like, okay, we just got to go into this with whatever strength we have. This is pretty equal, and just make the best deal we can, because this is actually holding up a lot more. A lot of people, how they used to look at the president of Washington State and how he was holding up CFP business.
Mm-hmm.
Most people, I was like, hey, he's just doing his job. He's doing what he's supposed to do. But most people had a negative opinion of him for it, probably including very powerful people at the networks and with, SEC, Big Ten, whatever. I mean, Sankey certainly said plenty about it. That's the position the ACC is going to be in now. If they're the ones that are perceived as holding up the situation, they're going to be perceived as kind of negatively. And going into having, re-looking at the CFP deals in 2028, that may not be a position they want. So, wrapping that up, I think that, if these motions get dismissed, ESPN may start to say to them, let's get this going.
Shirley Owens in the chat says, at the beginning of the live stream, the judge was overheard talking to the bailiff that he had quite a few days in July open. Interesting. Yeah, it's looks like this is going to be a race to the courthouse, right? Whoever gets the jump, whoever can get out in front on this between the state of North Carolina and the state of Florida, Mecklenburg County to be more precise, and Leon County, it's going to have the advantage. This is getting mighty interesting, Immaculate.
Yep.
Yeah.
I'm sure you got some other folks calling. I'm going to let it
buddy.
go with that. To me, I think this one is done, and now I'm more interested now in the motion to stay. If they get told that they have to do full discovery, we might be moving towards a settlement.
Yes. Yeah. All right, sir. Thank you, man.
Appreciate
the call. Great call from Mr. Hawkeye T. Smiley. Thank you so much, Smiley. I appreciate your contributions in the chat room. Nearly all civil cases filed in federal court and in North Carolina Superior Court will be required to participate in a mediated settlement conference. Greg, I thought it was weird that the Florida State lawyer brought up Miami. I did not catch that. I know Miami was brought up a couple of times in one of the Florida State's pleadings, one of their complaints. But I did not hear it being brought up today.
Call from
BJ.
BJ, the floor is yours. How you doing, sir?
Hey, what's up, Greg? How's it going?
Good.
So a few things. I think it was the show was over before it started. To be honest with you, before the ACC came into the courtroom, just with the facts as Judge Cooper understood it, was pretty clear. He hammered home again the location of the games, and he doubled down on it with the distribution of the funds coming back to Florida. So I think for me that's really not worth talking about. But what I do want to talk about is the malfeasance and just the negligence on ESPN's part and the ACC, for lack of a better. It's hard to decipher between the two because I think they're two sides of the same coin. Like when Florida State and the ACC settles, the entity that comes out looking the worst, in my opinion, is ESPN.
Yeah.
And they had to know that the risk for them would clearly outweigh the gain. And to me, it calls into question just what type of leadership is really heading ESPN.
Yeah, I read. I'm going to read this again. BJ, do you mind if I just take a couple minutes?
Oh, sure.
I read this on our Saturday Night Live show. This is the membership obligation. And I'm not going to show you, but I'm going to read it just like I did Saturday night. This is between the University of Texas at Austin and the SEC. As effective of and for the fiscal year of 2025 and 26. Without limiting the foregoing effective July 1st, 2024 and continuing for so long as the institution is a member of the SEC, the institution agrees and confirms the SEC shall control and have the exclusive right to exercise or license all media rights owned or controlled by the institution relating to video, audiovisual coverage of any game or practice, any blah, 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 blah. But it says for as long as the institution is a member of the SEC. It doesn't say for as long as the media contract, the grant of rights, the media contract goes until the end of the term. It doesn't use any of that language. It says without limiting the foregoing effective July 1st, that's when Texas becomes an SEC member, and continuing for so long as the institution is the member of the SEC. BJ, this is the argument that Clemson and Florida State are saying. They're saying in that media agreement, ESPN ACC media agreement, it limits the gore to where as long as they are members of the conference has the rights. But if they're not a member anymore, the rights, the ACC rights of their media rights goes away. That is unbelievable. That is malfeasance. That is incompetency from SEC, ESPN, SEC, whatever. They have that type of language in here. If the language, the membership obligation language, University of Texas at Austin with the SEC, if that is mirrored, if that is the same type of language that is in the ESPN ACC media rights agreement, like I said Saturday night, I understand more than ever why Clemson and Florida State went into the courts to challenge this. They believe once they declare they're gone, once they're not a member, the grant of right, the ACC will not hold their media rights any longer. What do you say, BJ?
I agree, and it's a lose-lose for ESPN in this case, right? Because they typically copy and paste agreements, right? And they modify them a little bit, but it's typically copy and paste. So it's fair to say that's plausible. That language in there is plausible. And the reason why I say it's a lose-lose, let's say that language is not in the ACC grant of rights, right?
Yeah.
What that shows is that ESPN treats ACC differently from the SEC.
Yeah.
Whereas the SEC teams will retain their rights once they leave, but the ACC teams will not.
Yeah.
Which further cements Florida State's claim that the ACC was negligent and served the purpose of ESPN and not of their members.
Yeah. Yeah.
Does that make sense?
Yes. Yeah. Good point.
So to me, it is quite obvious that, and I'm not surprised that the lawyer for the ACC attempted communication with the Florida State side. They're going to get shellacked. I think if it goes to court, I am sure Florida State will win and will get out the when I say win, the grant of rights will be invalidated. And they'll just have to negotiate a payout settlement with the ACC for the exit fee. The ACC and ESPN, this is their highest point. After this, I think it goes downhill for them. Yeah. If I were the ACC, I would negotiate a settlement. I would try to wait till after August 15th. That way I can get Florida State for another year.
Yeah.
Yeah.
Or have a sliding scale, right? Florida State, you pay this much before April 15th, and you pay this much August 15th. You pay this much before August 15th, this much after August 15th,
So to me, and I don't want to belabor the point, but I just think when you take a step back and we look at it, the pure overplaying of your hand by ESPN, it's just, I can't understand why they would do it in the manner that they did. And I think the FSU lawyer mentioned something about that ESPN and the ACC is hurting the value of Florida State by basically broadcasting falsehoods about the ownership of the media rights after Florida State leaves.
Yeah.
Which makes it unattractive to Fox and any other broadcaster.
Because the Big Ten, the SEC, and Fox, they are not going to have any serious talks with Florida State, with Clemson, with North Carolina, until they know that Florida State is within a year or two of clearing the ACC's grant of rights. It's just, so yes, you're correct. Yep.
So and maybe it'll be studied later, but the leadership at ESPN, and mind you, this is par for the course, and on a different note, the Pat McAfee, issue with leadership executives within ESPN. His show seems to be doing well. I don't understand why the rumor was the executive didn't like McAfee's show and wanted to kind of make sure it fails. So I'm just puzzled at the leadership at ESPN, and I'm not surprised ABC is trying to sell them, or Disney is trying to sell them off, because this makes absolutely no sense why they would even challenge Florida State in Florida, knowing, the Florida sunshine laws and how, the local folks are gonna, lean locally. Nobody has an allegiance to the ACC. The ACC as an entity doesn't really have a fan. It's more like fans of Florida State and fans of North Carolina, fans of Clemson. We fall under the ACC umbrella, but nobody's a fan of the ACC. No judge graduated from ACC university. You know what I mean?
Yeah.
So to me, and I'll get off your line, but as I kind of taken everything, the biggest losers, ESPN, and they just got piled over their face with this challenge.
Yeah.
But thank you for having me on.
You got it. I appreciate it, BJ. You might have to call us back again today. Who knows how long this goes. Thank you, sir.
Take it easy.
You got it. Beautiful call by BJ. I'm just checking some reports from people who are in the courtroom, just trying to pick up a little bit more information. We're expected. I think the judge, and I think the break is over in about 24 minutes from now, if I've got that right. If I've got that right, the phone line is open. 763-260-1333. Greg, your content is unmatched. You should be at least 10,000 subscribers. Thank you, Matthew. I appreciate it. Appreciate the kind words. I don't think there's 10,000 people who would like me enough to subscribe to this channel. This show is not for everybody. This is a national college football YouTube channel, and we kind of dig into everything in college football at a degree that I think some people find a little bit too much, but that's what we do here at Peek Around the Corner. We poke and prod, poke and prod, poke and prod. Let's see. Phone lines open, 763-260-1333. Rock and Rant. He was just asking about ACC interactions in Florida, so he mentioned Miami too. I thought Rock and Rant said he was just asking about ACC interceptions. Wow. Okay. Richard Brookins, the ACC is going to drag this out as long as they can. Florida State and Clemson may need to make them see the error of their ways and settle. Man, okay, so I know I heard it. The Florida State lawyer, I think it was intentional. He leaked right there in public saying that there was a letter by the ACC top lawyer to Florida State talking about 3 options of settlement.
Call from
JD, thanks for calling again, sir. I do apologize for we had to go live again. JD, the floor is yours. You get as much time as you want. Go at it, sir.
I appreciate it, sir, but I'm gonna keep this brief, and then I might call back in later. Let's just look at the grant of rights. I love how the FSU lawyer brought it into his claim, even though it wasn't necessarily applicable to rightness. He wanted to get that on record today.
Yeah.
Okay. The point is for negotiations to move forward, the ACC they have to realize the gig's up. Okay? It's up. People know, and people are going to know.
Yeah.
You know, when I talked to you before, and we've talked endlessly about the language within the grant of rights. The language was a scare tactic, in essence. Now, yes, I agree with you. A lot of grant of rights would apply to other deals if it specifically says it. I don't understand why. Maybe there's something contractually where, because the ACC contract, whether or not it had option to renews or whether those are look-ins, regardless or whatever, maybe by contract law, the ACC can't legally suggest that it would go to a certain point. Or maybe they didn't want to make any inference. Maybe and I'm just thinking about this now, maybe they didn't want individuals to question whether the ESPN agreement went to 2036. Maybe they wanted to keep it private, that it didn't go, necessarily past 2021 or now 2027. That they want to keep so many things secret. But the language in the grant of rights, yes. Is the grant of rights real? Yes. But there's a lot of language in there that's a scare tactic.
Well, let JD. I apologize for interrupting you. I'm going to give you as much time as you want, but I got the grant of rights up on the screen, and what is so amazing is basically the Florida State lawyer said, "Look, okay, grant of rights. We're asking you to basically put this in practice." He's telling the judge, he's asking the judge, we're not even trying to invalidate it. It says, the grant of rights says, each of the member institutions hereby irrevocably and exclusively grants to the conference during the term all rights necessary for the conference to perform the contractual obligations of the conference expressly set forth in ESPN agreement. So Florida State's not arguing all of our rights are to the conference. They've got them, baby. They've got them to perform the contractual obligations expressed in the ESPN agreement. So what does the ESPN agreement say? So the lawyer's not even, they're saying the grant of rights is basically, okay, cool, fine. Look, we've given all of our rights to the ACC, but all rights necessary for the conference to perform the contractual obligations expressly set forth in the ESPN agreement. So what does the ESPN agreement say? Well, that's what they're hiding, because and I know you know all this, JD, because you've been saying this for weeks and months. I'm just saying this so people new to the channel, okay? So you go to the ESPN agreement. Well, we can't see what the ESPN agreement says because it's redacted. ESPN doesn't want to show it. But whoops. But because of this document that I cannot show on the screen, the membership obligations between Texas and the SEC, this hints towards the language that is probably, we don't know for sure, probably an ESPN ACC agreement, without limiting the foregoing and continuing for so long as the institution is a member of the ACC. The institution agrees and confirms the SEC shall control and have exclusive rights. So they're really not even arguing the grant of rights, really, JD. They're fine with what it said. What?
No, go ahead. I'm sorry.
They're fine with what it says. They're basically saying, the Florida State lawyer today, all right, we're not asking. We're just asking you to look what the grant of rights says, not to invalidate it, but it says everything set forth in the ESPN agreement. Now, Judge, you got to read the ESPN agreement. Oh, by the way, we've got 168 blank pages. I tell you, if Clemson and Florida State are anywhere near accurate about what they are saying that's in that ESPN ACC media rights, and if that is anywhere near the language or is the exact language that is with the Texas and SEC media obligations, then Florida State and Clemson had a great case, JD, and this is what you've been saying for months. Go ahead, sir. The floor is yours.
No, sir. I agree with you. And if you remember the last hearing, the FSU's lawyer, what's his name? Mr. Rush? Is that what it is? Anyway, he was referring to Carolyn Egan, which is chief counsel, and she's also a vice president at FSU. He was referring, in the last hearing, he was referred to her, and I think they even cited the section in the contract that basically is the same argument that FSU and Clemson are making. So in other words, she's making that she has visibly seen it, written it down.
Yeah.
Now, that's not something that you could use in court. You need the actual contract. But they know where the language is. They've seen it. They've viewed it. That was in the part of the hearing, and if you ever go back and look at your show, whenever the ACC representative was questioning why, FSU members were writing certain sections down verbatim, so if you go back and you remember about the time frame that would be, I'm pretty sure when the lawyer was referring to Carolyn Egan, I thought he also cited the sections and what it said. But now you bring everything else in the context. They wanted to get that in court today, even though it might not necessarily had anything to do with ripeness. He wanted that on record. And you could tell right then and there that just gutted the ACC, because that has been their goal the whole time. They knew if this went to court, it really goes to trial. The grant of rights and the actual ability of the actual performance of the grant of rights would be called into question on whether it applies to non-members or former members. It's been a stall tactic from the get-go. And I mean, I can understand their point. If they leveled with everybody, in the past couple, years or 18 months, I'm sure several members would have already left. They would have paid the exit fee. To be truthful, exit fees never really been the major contention. Sure, when you go to court, it's like every other case. Yeah. You're going to try to get off as cheaply as you can.
Yeah.
If you can get out. Go ahead. I'm sorry.
Yeah, I mean, history shows that schools pay about 60% of what is written in the bylaws. So, I think at the very most, Florida State would pay $80 million. At the very most, $82 million, because that's 60%. I think it is, anyways. But yeah.
Well, let's refer back to your Saturday night show and the other thing that you talked about.
Yeah.
You suggested that private equity is in place to provide whatever financial needs FSU might have. Oh, by the way, FSU lawyers today decide to throw out the grant of rights, what it says in it, and try to throw that out there to the judge to potentially mediate a settlement. I know that's not going to happen, but they're forcing that issue. And not coincidentally, you hear that FSU's private equity is in place. So that's exactly what's going on is they wanted to make sure, because I don't think the judge had planned to discuss the components of the grant of rights today. He just wanted to discuss the actual motions to dismiss. FSU made it clear they wanted that thrown out in public today.
Mm-hmm.
They want this settlement to happen. I was looking back at some of my documentation. There was it was actually January 12th. It wasn't January 19th. But there was some back and forth between the ACC Chief Counsel and FSU's Chief Counsel. Carolyn Egan, she had a pretty testy letter she sent to the ACC in a part of the filings, but I was looking to see if that was dated the 19th and whether or not those settlement discussions, and it wasn't in that. It wasn't in that. So.
Couple questions. Nathan Campbell in the chat room wants me to ask you, why did the Florida State lawyer bring up Miami? I did not hear that part. I think it was answered in the chat, but I don't remember what the answer was. Do you remember the lawyer bringing up Miami at all today? Okay.
I think I was working on some things, but there were a couple of times when, honest with you, I got phone calls and when I was listening on my phone. So, but I think when they brought up Miami, they were just talking about, locations. When it was talking about venue and whether or not Florida was a proper venue, and the ACC is doing business in the state of Florida. They have 2 member institutions there. And the judge, I think he was kind of hinting around, and then the ACC attorney, not the ACC, FSU attorney, was also kind of alluding to some of, our previous arguments that how could the ACC dispute that the property in question is ACC home or FSU home games, and the location is in the state of Florida. FSU home games are located in the state of Florida. It is a Florida property.
Mm-hmm.
So I believe this is more of an intellectual property case than it is contract cases. There's some contract law involved, I think. Obviously. But I think there's more intellectual property because it's a trademark issue. In intellectual property, the property is in Florida. Or let's just say it is contract law, or let's just say it's property law. I don't know if real estate law, I don't think would apply to this. Regardless, wherever you go, the property is in Florida, or principally in Florida. Yes, like they suggested, and that's what they were trying to, the ACC lawyers were trying to get away from, saying, oh, well, no, it's just FSU home games, and if it's in Atlanta or in another part of the country, but it's considered an FSU home game. Well, there's always exceptions, but principally the property in question is located in the state of Florida, or it would be performed. The work would be performed typically in the state of Florida. Mm-hmm. And so, but I like the ACC lawyers. Their argument was like, they're looking for technicalities. Yes, it might apply here, but you didn't cite it, and you didn't put, the exact citation. That's basically what their argument is. You didn't put the exact citation. You made the assertions, but you didn't cite exactly why. And if that argument is valid, then in North Carolina, the ACC's post-dated vote to cure, or their later vote to cure the original filing wouldn't be valid either. You just go back and forth. But anyway.
Did you hear? And I asked the man. I've been asking everyone the same question. Did you hear the lawyer, Florida State, Rush, kind of sneak in there letters? He gave it to the judge in a binder. They said they gave it to him, to his office. They hand-delivered it to his office on Friday. But there were letters between the ACC top lawyer, that's how Rush, the Florida State lawyer, put it, ACC's top lawyer, to Florida State, somewhere around January 24th, I think he said. And there were options of like settlement. And then suddenly the conversation didn't go any further with that. Did you hear that at all?
Oh, that's what I was referring to a few minutes ago when I was looking to see the dates on those letters, and I just
I thought you said January 12th. I thought you were talking about something else.
No. What I'm saying is I thought those letters were in one of the filings, and actually no, the letters that were in the filings were the January 12th letters.
Yeah, no, those letters were not in the filing. Oh, or at least
yes, sir, those weren't the filing.
At least that's what they said in the courtroom today. That's why they kind of went away from it. One of the reasons why they went. I just found that real interesting. Anyway,
there's a lot of PR being fought. I mean, in this case, everybody knows that it's being viewed and it's going to be reported on.
Yeah.
And there's conference members all throughout the ACC. All of them are watching this. And so, again, they're putting pressure. Now, they're throwing it out there that, hey, the grant of rights probably won't stick or it's limited. Okay? And again, yes, if you're a conference member, it's ironclad. But if you're not, how can it apply because of the language? You also have to think about how the grant of rights, well, I'm not going to go there. I'll save that for another day.
All right, we got to get...
anyway.
I appreciate the call. We got to...
Yes, sir. I'm gonna get off, but I always appreciate you. Thank you for what you do.
Thank you so very much, sir.
Have a good day. Have a good day.
Okay, so great call by Mr. Seminole JD. We have this should be coming. I think the break is supposed to be over by, I don't know, 12:30 Eastern time, 12:35 Eastern time, somewhere around that. And we're at 12:26. So we're getting close. We are going to cover it. We're going to provide the live stream. It hasn't come up yet, and when it does, we will put it on. So I know we got a question earlier about 20 minutes ago in the chat. I did not quite get to it. But yes, we are covering it from inside the courtroom. Judge C. Cooper. Just going to go check to see. Let me check somebody that's in the courtroom. Hold on. By the way, we do have breaking news. Breaking news. On3 has put in a prediction that former Oregon State running back Damian Martinez is going to the Miami Hurricanes. That would be a massive pickup. A massive pickup for the Miami Hurricanes. Getting Mr. Martinez. It's not official, but On3 has made their prediction that's where it's going. Breaking news. I'm checking. I actually got two windows open on that. Let me do something here real quick. Phone line's open. We'll take another phone call if someone's interested. We are going to go, once Judge C. Cooper is presiding, we're going back into the courtroom. Okay, let me just check this out. No, that doesn't have anything new. We got breaking news. Auburn's wide receiver Jay Fair has officially entered the transfer portal. He caught about 30 balls last year. Jay Fair, wide receiver Auburn, he has entered the portal. Let me check his stats. I think he caught about 30 balls last 25. Let's see here, Jay Fair. It was reported a couple days ago he was going to go in the portal. Now it's official. I checked it. 31 receptions, 324 yards, 2 TDs. Jay Fair is now in the portal. We are waiting on a live stream, Leon County. We're waiting on the live stream to come back up in Leon County. The phone line is open, 763-260-1333. What will be the new name of the NHL franchise in the state of Utah? What will be the new name? I don't have a clue. My Minnesota Timberwolves won game 1 against Game 1 versus the Phoenix Suns. Anthony Edwards went crazy. Absolutely went crazy. And did anybody see Will Ospreay versus Brian Daniels last night? Did anybody see Will Ospreay versus Brian Danielson last night? Stephen Vitt had a feeling Damian Martinez would go to Miami. That is a big pickup. Big pickup. Look, you guys know this. I was a Henry Parrish fan. I was so excited because I thought he was going to get the rock for Miami this year because he didn't get the rock like he should have last year. They have Mario Cristobal. All I know is this. If Damian Martinez lines up behind Cam Ward, they've got to give Martinez the ball like Jonathan Smith did at Oregon State. They gave Martinez the rock. Treat Martinez as an RB1. Don't be doing this running back by committee. Get Damian Martinez all lathered up. Don't screw it up, Cristobal. Don't screw it up. Anyways. Okay, we're waiting. We're waiting for the live stream. I want to thank you all for joining us here at College Football's Peek Around the Corner with your host, Greg Pflugar. We cover everything in college football because we love everything in college football. If you haven't done so yet, please subscribe to our channel and then open up your notifications because we don't go on a schedule. We go where the story goes, breaking news. We can come up in the morning like we did this morning, lunchtime, at night, late in the evening, midnight show. So subscribe, have your notifications on, and please smash that like button if you've liked our content today, because it helps us with the algorithms of YouTube so very much. So please smash that like button. If you don't like our content today, please smash the thumbs down button and then let me know how we can better serve you, the college football fan. If you want to donate to this Outpost Rebel Outpost College Football channel, just hit the $, make a comment, and I'll get to you super chat as fast as I can. If you want to become a member of our show, early peak Cloak and Dagger early peak episodes for members, getting the early information before we go on it live, go to the link in the description box below the video. Hit the link, hit the join button, and become an early peak Cloak and Dagger member. You also can go to if you're interested, our mugs are starting to sell again. Our Cloak and Dagger mugs are starting to sell once again. Go to our merchandise store. There's a link provided in the description box. Merch store. We've got trucker hats, mugs, t-shirts, all different sizes, all different colors. And we're going to be having more merchandise right before the new college football season starts, with our logo, our new logo, and everything else. So go to our merch store, check it out. There's a link provided if you are interested. We are waiting. We are waiting for the live stream to pop up again. Thank you, Kenneth Klager. I appreciate it. I appreciate it so very much. Is it my imagination that the chat and callers are biased towards Florida State? I think they probably are. I think they're, well, you know, first of all, it's hard to be a fan of a conference. I know some people are. SEC, Big Ten. I'm not biased towards Florida State, but I more than ever, I get why they went to court. I mean, I understood it before, because the risks for to go from now to 2036, to stay in the ACC conference, if you're a team that wants to compete at the highest level of college football and college athletics, there hardly is any more risk now to go to court and to see what happens, because you are behind the 8 ball as it is. To such a degree, how much of it is it a risk to go to court to battle the ACC? But beyond that point, the arguments, what is stated in the grant of rights, I just showed it today, and what is possibly in the media rights agreement, we don't know for sure. But if it mirrors the language of Texas and the SEC when it comes to media membership obligations, I think I think Florida State's going to find a way out. I think there's going to be a settlement. I think ESPN, ACC, I think they screwed up in more than one way. Before this happened, I did not know, before Florida State Board of Trustees on December 22nd laid the nuclear bomb, when they disclosed that ESPN could walk away from the agreement, could walk away from the ACC contract for 2027 and beyond. Nobody knew that. No national writer. Go look at everybody's tweets that day when that news broke. The more you learn, the better case Florida State and Clemson has against And again, they're not even really battling the gore. That is something we got to put our arms around. They're not even really battling the grant of rights. What they're battling is what is in the media rights agreement tied to the language in the gore. So I don't know. I don't even look. There is a lot of bias. Florida State. There's a lot of Florida State fans. But I'm not biased. I'm not pro Florida State. I got to tell you, I'm not pro anybody. I'm not even pro Big Ten. I'm hated by everybody equally. But I got to tell you, I'm surprised that I'm sitting here Monday, April 22nd. I am bewildered by ESPN and ACC and the language that they proposed might have used, but then again, they've got it all sealed up. A lot of bias, but even if you're biased, you can still see things clearly.
Call from
BJ.
BJ, the floor is yours. Can you hold on for one moment, please?
Yes.
I appreciate it, BJ. I was rattling on here, and we had some very, very nice people. Carrie Gold Nose gifted 5 memberships. Holy smokes, Carrie. Thank you for your incredible generosity. Honestly, thank you so very, very much for your incredible friendship, generosity to the show. You are hereby Cloak and Dagger whoops. And then, of course, I go screw it up. You are hereby Cloak and Dagger knighted once again. Carrie Gold Nose, thank you so very much. And Memphis Dave becomes an early peak member. Memphis Dave, holy smokes. You are hereby officially now knighted Cloak and Dagger. Thank you for becoming a member to our show. You can go to our YouTube channel and put on and watch the early peak Cloak and Dagger episodes for members only. And then Juan Carlos. By the way, I have a brother-in-law named Juan Carlos. Juan Carlos, Nathan Campbell, Kenneth Klager, David Kreitzer, JL, thank you all you all are gifted a membership by Carrie. Let Carrie know. Let him tell him thank you. You all hereby officially Cloak and Dagger Night. Congratulations to everybody. BJ, thank you so much for your patience, sir. The floor is yours.
Thanks, Greg. So I was listening to your show. I think the last poster was Steve-O about, I think you mentioned something about this, a lot of pro or biased FSU folks in the chat. I would say this. There are some fanatics out there, but I think most folks, for by and large, are looking at this in a kind of balanced way. Right?
BJ.
Yes.
The live stream is back up.
We'll talk later.
All right, I appreciate it, BJ. I apologize, sir.
And they often involve prestige networks. The limited geographic area with respect to Miami and the state of Florida, certainly Florida State, includes the state of Florida. That's paragraph 26. Paragraph 28 says that football comprises approximately 80% of all the money the ACC makes for its media rights. The football is played in Florida, both home and away games, but at the University of Miami and the University of Florida. So the common enterprise, which generates substantial revenues on which its members rely, are predicated upon football contests that occur in part in the state of Florida. Paragraph 52, Your Honor. This is how much money the ACC takes and spends in the state of Florida every year since 2012.
So how do I know that?
Because in the column 1 is the cash payment, is the distributions per member institution in the ACC.
Per member institution.
Per member.
So that would include FSU and Miami.
So you have to double the number, Judge.
Okay.
The number's only half big enough. So for this year, it was $40 million. $40 million under the contract entered to exploit the media rights in accordance with the common enterprise. These are the substantial revenues upon which Florida State and the University of Miami relies. That allegation says that number is $40 million this year. It's going to be $42 million about next year. That is a payment from the ACC and into its member institutions in the state of Florida every year. And that's been ongoing, Judge, for the last 10 or 11 years. Paragraph 80. The ACC commissioner said that in order to have a successful prestige network, you need to secure distribution rights in their respective states. The respective states mean the states of the members, 2 of which are in the state of Florida. Paragraph 90. The second contract. Florida State was induced to enter a grant of rights with the expectation of receiving benefits different and enhanced from different and enhanced agreements from the conference and ESPN.
What paragraph again?
That is paragraph 90. So the first contract, Your Honor, was the ACC bylaws and constitution. That's the exploitation contract. This is a second contract that the common enterprise entered with the state of Florida and with the University of Miami. That's the grant of rights. So now we have 2 contracts entered by the ACC explicitly with citizens of the state of Florida, by which hundreds of millions of dollars are transferred. Paragraph 99, I referred to this earlier, footnote 4. Under the ACC agreements with ESPN, and I'll translate it, Florida State and Miami are paid $1 million each every year to produce the broadcasting of the ACC network within the state of Florida under the ACC network flag. So the ACC is paying every year to run a media production facility in 2 different parts of the state of Florida, north and south. Paragraph 107. The ESPN grant of rights fees paid each member placeholder consideration in the amount of $1 million for certain years. That's paragraphs 107 and 108. In other words, a contract negotiated by the ACC on behalf of the member institutions of the ACC had a separate provision on top of the production fee, paying them a placeholder consideration. Paragraph 121. We're now in contract number 3, entered by the common enterprise, formed for the sole basis of generating substantial revenues for its members. So now we have a third contract that common enterprise entered with not 1, but 2 member institutions in the state of Florida, that being Florida State University and Miami. And again, they were induced to sign the amended grant of rights with the expectation of receiving benefits different and enhanced. So in other words, the ACC promised them more money, better contracts, in order to stay and execute another contract. Paragraph 127, the 2016 ACC network agreement included no guaranteed right payments from ESPN beyond a $1 million production fee paid to each member. That's the production fee again. That is an ongoing payment due last year, due next year, due the year after. Comes in every year, and the ACC uses that money to fund the production of media from the bricks and mortar facilities of University of Miami and Florida State University.
All that's just in 127? I don't see any of that in 127.
It's a $1 million annual production fee for the 2016 ACC network agreement.
I got that.
Okay.
But I didn't see any of the rest of it in 127.
The ACC network, the production facility, is paid to each member so that member can produce the content. That's what it's for. The content being the
ACC. There's a production fee, so I get the produced content.
For the ACC network, which is described earlier in the paragraphs I described. We're going to get to more of them, but the ACC network, according to the amended complaint, is a 50-50 venture arrangement by which Tier 2 and Tier 3 games are broadcast and sold.
Tell me where it says Tier 2 and Tier 3 games are broadcast and sold.
Paragraph 126, I'm sorry, pardon me. Paragraph 26.
Tier 2 and 3 rights agreements involve and include the development of a conference-affiliated branded sports network, oftentimes distributed in a more limited. Okay.
But the next sentence is important, often referred to as prestige networks. That's the prestige network. That is the seed of the ACC network that is developed in the complaint.
I know what the agreement is. I want to know if it's pled in the complaint.
Understood. But that's what you asked, where Tier 2 and Tier 3 were.
I know.
Okay.
I'm having trouble understanding why all these vague words and phrases are used when it can't just be ACC got money from home games, gave FSU some of it, kept some of it. That kind of, well, let's keep going. Maybe it will become clearer.
The media rights, according to the ACC, the bylaw and contract, concern sporting events played by the member institutions.
Yeah, is the grant of rights agreement is not attached to the complaint?
It is not, Your Honor.
Okay.
Paragraph 131 has, again, the chart of the payments made pursuant to the ACC 2016 Tier 1 agreement, and it shows those payments being made into the state. The Tier 1 agreement being different and apart from the ACC network agreement.
Tier 1 games are home games?
They are.
Does it allege that in the complaint anywhere?
It does not.
Well, let's assume I'm not all that smart. How would I figure that out from the complaint?
When you say it, you're telling me.
Let me put it this way.
Yeah.
Instead of smart, let's say sophisticated.
Okay.
How would I figure that out from the complaint?
There are no other ACC games other than home games. They're not all Florida State home games, but they're somebody's home games. It's either ours.
All the home games of the ACC members are ACC games.
Correct.
All the non-home games belong to.
If it's played FSU, North Carolina State, ESPN. FSU, Georgia, at FSU, that's a bad example. FSU.
How about FSU, Alabama State?
That if it's at Alabama State, that is not an ESPN deal. That is not a conference game. That is an away game. So somebody has to be at home for ESPN to get the money.
Okay, other than the fact that I understand that to be the case and it's been explained to me there, is that in the complaint?
It's not alleged there are no other games.
Okay.
There literally are no other games.
All right.
It's somebody's home game. They're not all Florida State's home games. But for the ACC to have negotiated a way to exploit the media rights, it has to be somebody's home game. They can't exploit away Alabama's state's media rights.
I just don't see why you just don't say it in plain English.
Well, if you'd like us to amend the complaint to write it, we would.
Let's keep going because we may get to that.
You understood.
Okay.
Paragraph 136. The 2016 ACC network agreement does not include a guaranteed fees to the ACC other than the $1 million per member production fee, but in its place contains a 50-50 revenue share.
ACC network agreement does not include guaranteed fees other than the $1 million in its place. All right.
Okay. A 50-50 revenue share is emblematic of a joint venture. And in page 26 of their motion to dismiss, they describe this as a joint venture. So according to...
What they call it in the motion, though, that's not in the complaint.
It's not in the complaint, Your Honor.
It's persuasive, but it's not necessarily even relevant what they call it.
A 50-50 revenue split is a fact alleged in the complaint, Your Honor.
It seems to me that this is a joint venture from all these facts, but I have to connect a lot of disparate dots.
Understood, Your Honor.
Okay.
But that's what it is, a 50-50 revenue share with the money paid to the member institutions, including Florida and Miami. Paragraph 142. The grant of rights provision actually contained in the 2016 ESPN agreements had three conjunctive components. That games had to be played by a conference institution. Miami and Florida State are conference institutions. That the game had to have been completed during the term of the agreement, and that ESPN had the right to distribute that game played while the member was a capital C conference, capital I institution in perpetuity. Again, Your Honor, that can be nothing other than games played, at least in the instance of Florida State, by Florida State. Paragraph 146. By the time the ACC Prestige Network was finally ready to launch, the ACC members were forced to spend $110 to $120 million of their money so they could be prepared to produce live events and other programming. The live events and other programming by which each member institution spent $16 million was for the ACC network. Paragraph 147, the ACC has pinned its financial future on the revenue it expects to generate from a conference-branded linear network. So its entire future, according to this allegation, is pinned on the ACC network, which the member institution...
Complaint tell me the ACC network runs out of Florida?
Your Honor,
and this all goes back to home games, right?
The game has to be played by a conference institution. That's what
conference institution.
Mm-hmm.
But it doesn't say home games. Okay, go ahead.
Okay, so Florida State is a conference institution. It plays games. Some of the games it plays are here in Leon County.
Where does it say that in paragraph 147?
You're asking, does?
It doesn't say that, does it?
Does it say that Florida State's in Leon County? It does not, Your Honor. And it does not say that Florida State plays its games in Leon County. The complaint does not allege that.
Okay.
Paragraph 203.
203.
The ACC Constitution and bylaws are a contract by and among the member institutions to which the members have agreed to conduct the business affairs of the ACC. So the two of the members of the ACC are Florida State and Miami, and they have agreed in a contract to conduct their affairs of the ACC, and they have a contract by which they do that. Paragraph 219. In its pleading, the ACC asserts the ACC members have unwittingly entered and become part of a North Carolina, quote, common, joint, and joint venture. That is a factual allegation contained within the four corners of the complaint that the ACC is a joint venture. And we've established previously it is being operated under and consistent with games played by conference institution members. Paragraph 221. The ACC was created and exists solely for the benefit of its members and under the direction and the control of the members. That is a fact which under Inglesby, this court must take as true for the purposes of a motion to dismiss, which means the ACC is being run by two of its members under the direction of two of its members who are in the state of Florida. Paragraph 3 alleges that those two members, Florida State and Miami, are in the state of Florida. I would point the court to the case of Sutton v. Smith, which I think the court recognized earlier, in which the trial court was reversed. It's a first district case, Your Honor, in which to page 699, the trial court was reversed for having found that a pleading did not allege sufficient facts. And I think we've been through this before. Venetian Salami says all you need to do is have the facts somewhere in the complaint.
Trial court dismissed it.
Right, they did.
Grant a motion of dismissal with leave to amend.
I'm sorry?
The trial court,
okay,
I want to say Salami on every case we mentioned, but the trial court in Sutton dismissed the case. It did not grant
I'm sorry.
Motion to dismiss with leave to amend.
My apologies, Your Honor. You are correct. I misstated that. I would also point the court to two other cases. Kapila, K-A-P-I-L-A.
Tell me again that one.
Kapila.
Kapila.
K-A-P-I-L-A.
I think you may have me on that one.
That's a 2023 case from the 2nd District.
Can you give me a cite on that?
I can, Your Honor. 357, Southern 3rd, page 241. Pages, the cite 241 at pages 250 and 251.
Okay. What does it say?
It goes through some criteria, much less substantial than these, and finds that adequately alleges.
All right. Remind me to go read that before I rule on this part of the case.
So that's all I have on that. I don't know if if you have some questions.
Okay. Let me hear. I told ACC I'd give them a chance to go over this and plan a response if they wish to have one. Ms. Nunnally.
Your Honor. Your Honor, I want to start by saying that the discussion that you just had with Mr. Rush, both before and after lunch, establishes the insufficiency of their pleading. I think you made reference to that the allegations that he pointed to support personal jurisdiction are not pled in plain English, and that you would have to connect a lot of disparate dots.
Sorry, I shouldn't have said plain English.
We agree. It really might be better called a pleading misdirection than a pleading insufficiency. FSU pled personal jurisdiction based on an incorrect diversity of citizenship standard. There's a single allegation in paragraph 4 of the complaint. They came back in their response to our motion to dismiss without even acknowledging that error and claim that what they really meant is that there's personal jurisdiction under subparagraph 1A1 of the long-arm statute. Then just an hour or so ago, Mr. Rush cited another provision of the long-arm statute that appears nowhere on the face of the amended complaint nor anywhere in their response to the motion to dismiss. That means, Your Honor, that the pleading that you have in front of you right now is nowhere close to sufficient to have put the ACC on notice about which provision of the long-arm statute they're traveling under. And to add to even more confusion to this, Mr. Rush just cited 21 different paragraphs of the amended complaint that he claims include jurisdictional allegations, but they're spread throughout a very lengthy amended complaint. They're not identified as jurisdictional allegations. In fact, some of them, in his discussion about them, he added information to make them seem as if they're jurisdictional allegations, but that information isn't actually in the allegation itself in the amended complaint. So based on the legally insufficient jurisdictional allegation, the single jurisdictional allegation in paragraph 4, the ACC fairly responded by filing a motion to dismiss, explaining why this diversity of citizenship standard is not the proper legal standard to establish personal jurisdiction under the long-arm statute. Because that was identified as their jurisdictional allegation, that was the only thing that the ACC had to respond to with regard to personal jurisdiction, and we did that in filing our motion to dismiss. Florida State has not even disputed that they're wrong, that the standard that they cited is incorrect. And they haven't even acknowledged that. They did not acknowledge that here today. They didn't acknowledge it in response to our motion to dismiss. Instead, they're engaging in more misdirection by just blowing right past that allegation in paragraph 4 and asking the court to determine whether the long-arm statute has been met based on allegations in the complaint that are different than the single jurisdictional allegation that they did allege. So what it really comes down to, Your Honor, is that they messed up. They pled the wrong facts, the wrong standard, and rather than amending their complaint to include the correct one, they just want to act like it didn't happen. But the amended complaint is not sufficient to have put the ACC on notice regarding personal jurisdiction and which provision of the long-arm statute they're traveling under. So no duty, the burden was not shifted to the ACC to come back and dispute whether or not the provisions of the long-arm statute that they now say apply don't apply. And we're not in a position to do that today, Your Honor. We would ask that you dismiss the complaint because they have not properly pled personal jurisdiction.
Okay, I'm going to rule on a couple of things that I've heard already, and then I'm going to take a break and read this case that Mr. Rush cited to me. So on the issue of venue, the venue argument has been withdrawn or conceded by ACC. So that's denied as moot. The ripeness argument, I deny the ripeness argument for the reasons I summarized early in the ACC argument, and I'll try to re-summarize very briefly here, is the ACC is making the argument that its case is asking for a declaration to determine contract terms that are now presently in dispute regarding present facts at issue, and not whether they are to be decided, and not whether they are again, sorry, my notes, and not whether I should decide that they should withdraw or not. FSU has alleged ACC has committed multiple breaches, and they allege, among other things, that material breaches of contract relieve it from obligations from complying with the contract. So therefore, I find that the fact that they have not yet officially withdrawn from the ACC, trying to avoid a double negative, does not support a lack of ripeness argument, because the operative relevant facts and issues are the meaning of certain terms of the contracts, plural, which are presently in dispute. Again, Mr. Rush went into some detail on that, so I adopt what he said to the extent his arguments related to that narrow issue in his presentation. I think part of his presentation was legitimate rebuttal to maybe some of the opening presentation of the defendant, but we can leave all that part out on the ruling. It's the beginning part of your presentation. Is at some point I think I said, is this what you're saying? And you said yes. That's what I'm talking about. So deny on rightness. I'm now going to go back on the issue of personal jurisdiction and read this case and decide whether or not I accept the plaintiff's argument or the defense argument on the issue of pleading the personal jurisdiction. If you look at the context of all the facts in this case, including those that are clearly the case but are not in the complaint, such as the grant of rights agreement, arguments, motions, well, I'm just going to stop right there. I'm going to go back and determine whether this complaint needs to be amended to better state compliance with what appears to be what plaintiffs are aiming at, 48.1931A1, operating, conducting, engaging in, or carrying on a business or business venture in this state, or having an office or agency in this state. I've cited case examples which appear to be pretty close to that, but let me see what this relatively new case says, 357 Southern 2nd 241, and I'll be back in probably about 5 to 10 minutes. So we're in recess till then.
All right. Phone lines open. Phone lines are open. 763-260-1333. BJ, if you want to give us a call back, I apologize. We had to interrupt your phone call because the live stream came on, and it's going to be coming on in 5 to 10 minutes from now. So if you have, if you're on the line, I might have to cut you off again. But give us a call. For now, the phone lines are open. Louisville transfer running back Penny Boone is visiting Kentucky today. Kentucky.
Call from
BJ.
All right, BJ, the floor is yours.
Hey, what's up, Greg? Real quickly, I think the personal jurisdiction, it seemed like the judge kind of preemptively kind of let us know what he was going to decide. He just wanted to make sure that the new case coincides with his previous verbiage on personal jurisdiction. That's what I took from it. What did you take from it?
Yeah, the same thing. I think he wants to read this case that lawyer Rush gave him just to make sure.
Correct. Also,
Brian Murphy from WRAL says, seems clear Judge Cooper in Florida thinks there is a personal jurisdiction in Florida, but Florida State did not do a good enough job in its complaint, so he may allow Florida State to amend it. Go ahead, sir.
Yeah, that's exactly what I was going to say. It's like, I think it's going to be an amendment. And I think the ACC lawyer did a good job this last part, and he's just calling it out. But it's semantics, it's technicality.
Yeah.
Right. If Florida State amends it, I wonder what is going to be the ACC's new defense. Does that make sense?
Yeah. Yeah. Let me read you what Rohan just said here. Okay. Doug Rohan, rulings from Judge Cooper, the venue has been conceded by the ACC, denied as moot. The ripeness argument is denied. The ACC is arguing that this case is asking for a declaration to determine contract terms that are now presently in dispute. Florida State has alleged multiple breaches. Judge Cooper finds that the failure to officially withdraw, Florida State have not officially withdrawn from the ACC, defeats the lack of ripeness argument. This claim is ripe and requires findings of issues presently in dispute. To my understanding, the ACC was arguing that the motion for declaratory judgment was not appropriate because Florida State had not actually declared they were leaving. The judge disagrees. That's why I believe basically Florida State went 2-0 there with his rulings. Go ahead, BJ.
Exactly. Doug does a very good job of communicating in lawyer terms to make it easier.
Yeah.
But essentially, it was the same. It's quite obvious that the judge, I think I've told you this before, I think he made a ruling before he even stepped into court today. And he allowed the show to go on. And but when it was time to make a decision, he was reading off notes he had previously written, right? Yeah. So to me, it was dead on arrival in terms of the ACC's getting a victory today. But I think he may make Florida State go back and refile the amended complaint. But I think it'll have little to no effect on the overall pathway of the decision. And that is, Florida State is going to negotiate its way out. I don't know what that number is going to be, but it's quite obvious to me. I want to know what you think about that.
Yeah, I keep saying this, but let's wait until. At some point, BJ, at some point, there is going to be an acknowledgement from one side or the other to say, okay, the case is going forward. The case is going to proceed faster in the state of North Carolina, proceed faster in the state of Florida. If it is the Florida, I think we're going to get a settlement earlier rather than later. But at some point, we're going to know, right? They're going to know. Yeah. That May 2nd is the next state court date in North Carolina. At some point, everyone's going to acknowledge, okay, it's this is this is a guess on my part, but I think Judge Cooper is a judge that is gonna get this case through its system as quick as possible. What do you think?
Yeah, I think it's going to be quickly. And like for folks who are unfamiliar with Florida kind of judicial processes, they're not as structured as most other states, right? And so it may look chaotic, but it's very kind of loose in terms of its proceedings. But I do think that the sticking point to me that confirmed that it will be a Florida case, they keep mentioning the Florida citizens, right? Yeah. And I just don't see a Florida judge taking Florida citizens' money and giving it to a nonprofit organization in North Carolina without, reviewing the case.
Yeah. Yeah.
I just don't see that happening. In no way is $500 million being taken from Florida to a private institution or a nonprofit institution in another state. That is not going to happen. And I'll say this, then I'll get off the line so other people can call in.
Yeah.
The judge seemed very ticked or just annoyed at the legalese and the way these contracts are written. He mentioned several times in layman's, what is it saying? No. And I think it alludes to the point that the ACC, ESPN wrote these contracts to be conflicting and to be misleading. Because it seemed to me he had trouble understanding how procedurally how these contracts are kind of employed or deployed out.
Yeah.
That's how I took it, but I think it annoyed him. But ultimately, I think $500 million of Florida citizen taxpayers' money is not going to the ACC. No way in, HELL is that going to happen.
Yeah.
I don't care. If they have to bend the law or maneuver the law, that's not going to happen.
Yeah.
But let me get off your phone. Thank you once again for having me on, and I have a blessed day.
Appreciate it, BJ. Thanks for calling again, sir. Great call by BJ. Big Dog Daddy, Mr. Husky. Holy smokes. Thank you for your incredible generosity once again to this Rebel Outpost College Football YouTube channel. Rebel Leader, I'm sorry I missed over the weekend. Happy Monday. Big Dog Daddy, go watch that Saturday Night Is All Right for PATC live show. Go watch it if you get a chance, when you get a chance, because that was a very interesting live show. Anybody who missed it, go watch our Saturday night live show, PATC. Thank you so much for the incredible generosity, Big Dog Daddy. I do appreciate it so very much. Charlie Atwood, Greg, you are pro Minnesota. Yeah, yes I am. But I also get in trouble with Golden Gophers. Remember, last year my prediction was Minnesota was going to take a step and a half back, and they were only going to win 6 games. And I got crushed by Golden Gopher fans. And they won 6 games. So even though I was accurate, I got crushed. So eventually everybody hates the fat guy from Minnesota. There was another comment here that was very interesting, and now I lost it. Yeah, I think I lost it. T. Smiley. Yeah, the Judge Cooper basically just said, I think I've already stated plenty of examples of why Florida State is right, but let me go read this case to say I did. There is a Ross Dellinger article out there. I have read a little bit of it, talking about the CFP, how things got heated. I'll probably do an episode on that later. I think that Matthew Wallace, the ACC is dead as soon as Florida State Clemson leave. The contract won't be extended by the deadline after 25. Well, I think the contract goes to 2027 regardless. But we'll see. We'll see what happens. We'll see what happens. Again, thank you all for joining us on this marathon live PATC breakfast. But now we're into the lunch hour. We're past the lunch hour. If you haven't done so, please subscribe to our channel. Smash the like button and open up those notifications. This is College Football's Peek Around the Corner with your host, Greg Pflugar. I don't think that concession by ACC, that had nothing to do with them saying that the case should not be in North Carolina. I don't really have a good way of articulating that, but that was separate from, no, ACC believes this case should be in Mecklenburg County. They're not conceding that. We're waiting for the live stream to pop up again here. Yeah, that Immaculate just put out a post in regards to Ross Dellinger's article that I will probably put out an episode tonight on. The CFP, this is from Ross Dellinger, the CFP revenue distribution model was largely based on a conference historic success in the playoff over the previous decade, while considering realignment moves. And then Immaculate says this is why Clemson was able to file their complaint right after the CFP meetings concluded, right after it became official. The distribution model, the format hasn't been officially decided yet, but the distribution model has been. What they're looking, there's a looking clause for 2028, but for now, the distribution model has been decided, and right after they decided that, the day of, I think, or the next day, Clemson filed, March 19th, filed a suit against the ACC. And maybe this is why Clemson held off. They wanted, now Clemson knows they are going to be even more valuable to the SEC of the Big Ten when it comes to valuations, because they're going to increase the SEC's or the Big Ten's percentages on CFP money if Clemson decides to go to the SEC or they go to the Big Ten because of their past performance in the playoffs. That's how the distribution model was largely based on historic success of these schools. And maybe now that when that was cemented in, Clemson knew that their value, when it comes to Big Ten, SEC's valuation of Clemson is cemented. It jumped upwards, got cemented in, and then the risk-benefit analysis of Clemson finally pulling the trigger. More benefit than risk for the Clemson Tigers. Now, of course, we have peek around the corner. We were told between January 20th and February 6th. That did not happen. We had to take the L on it. Clemson, they delayed, and they finally pulled the trigger. Is Cooper back yet? No, he is not. Judge Cooper is not back yet. Phone lines open. 763-260-1333. Oh, I'm going to give everybody a chance to find solutions in about 90 days. Chris Jennings. That's what Judge Cooper said earlier today. Cooper wants this settled. He wants this settlement. I think we're going to get a settlement, guys. Guys and gals, I think we're going to get a settlement. Have I heard anything behind the curtain on a mediation? No. Did we hear that Florida State is ripe for mediation because they got their ducks in a row if they need that private equity and stuff? Yes, we did hear that. That was part of our reporting Saturday night, April 20th. Go watch that live show. But we have not heard a word if there has been, or what is scheduled for mediation. If North Carolina State goes to the college playoff, that'd make them more valuable. I think I love the Wolfpack this year. As long as they get some sort of production besides Concepcion, they're going to get some production from Jolly, the tight end, the transfer from UConn. But if they can get something outside of that when it comes to their wide receivers, like Noah Rogers, the transfer from Ohio State, I don't know if he's ready to, if he can just give them 20, 25 catches this season. But man, you got Jordan Waters back there. You got Raphael, Jordan Waters, the transfer from Duke, and of course Grayson McCall. I am so big on North Carolina State this year. They play Tennessee. I forget where is Charlotte maybe? I can't remember where that game's at. But anyways, North Carolina State, Tennessee. We're going to be all over that game here at Peak around the corner. Daryl says Florida State pays $120, leaves June 30th. Holy smokes. Morris Simmons, Florida State has the settlement money already. You know what? Florida State might need more than just the settlement money. Ready. Because now just Morris Simmons and everybody else who's about to yell at me, they might not get the full freight going into the SEC of the Big Ten. I'm just saying they might need a bridge. They might need a bridge for a few years before they get the full freight. We shall see. The media market is still tight, especially for ESPN. But again, ESPN might be losing some of that NBA deal. NBA was announced today by Marchand, saying that the NBA looks like they might have some of their package going into streaming, possibly Amazon. Amazon looks to be the big player when it comes to the new deal for the NBA, the National Basketball Association. So what does that do for ESPN? Craig, if you give Oregon and Washington half, You have to value FSU more. I don't know. I don't know. I don't know the answer to that, young Seminole. Does Fox Sports really want to get into the Southeast with Big Ten? Yes. Are they willing to pay full freight? I don't know. Is CBS, NBC all willing to pitch in? Remember, with Washington and Oregon, it was only Fox Sports that paid, that grease the skids to get Oregon and Washington in the Big Ten. NBC did not pay extra. CBS did not pay extra. When it comes to Florida State, with CBS and NBC willing to pay a little bit more, I don't know. I do not know. I know Fox Sports would love to get the Big Ten Network into the state of Florida. Greg is tripping for sure. I can't remember what I just said, so I don't remember. Oh, North Carolina State. People are ripping me about my North Carolina State take. Big Ten is paying Florida State full share, no doubt. It's not the Big Ten. It's the media partners. Remember something here, guys. Remember something. The media market is so tight that ESPN would not pay a nickel more to the SEC schools if they went to 9 conference games, which would give way more value to ESPN, way more value to the SEC product. And ESPN said, nah, we're good. That's how tight it is right now.
Call from
Ryan Thomas.
Ryan Thomas, the floor is yours. Go ahead, sir.
Well,
I might have to cut you off if we go live stream again, but go ahead, sir.
No. Are they in recess right now, Greg? I've been in meetings all day today.
Got it.
Are they in so what's going on so far? I'm just calling you for the update, Greg, because I've been in meetings all day. So I see all this fun stuff, and I want to know what Greg is tripping about.
I don't know what I'm tripping about. I think people are believe that I'm tripping about my North Carolina State take.
Versus RJPT.
Oh, we're live. Sorry, sir. We're going to have to go.
Southern
All
3rd,
right, take care. Good job,
241,
Greg.
2nd DCA, Florida, 2023. It looks to me like it's dealing primarily with prong 2 of personal jurisdiction. Am I reading something different? I'm reading from page 250 to 251.
Your Honor, I think it deals with the fact of whether they're operating a business or a venture in the state of Florida.
Okay, so it might appear to some that I enjoy really long hearings. But that's not true. I feel compelled to grant the motion to dismiss on this point with leave to amend. So let me make it clear to the non-lawyers and to the lawyers alike what I'm doing. I'm not ruling against FSU. I'm not ruling they have no case. I'm not ruling against ACC. I'm not ruling in favor of ACC. I'm not ruling that its case is better than FSU's case. What I am ruling is that in a case that's worth, I'm told, up to $500 million on personal jurisdiction, we need a more specific and clearly stated statement of personal jurisdiction. If Ms. Nunley and I had a very educational, I think, dialogue before lunch on the cases. And I gave her my thoughts. She gave me her thoughts. I think it would be helpful to all if you all were to look at that. It appears to me, I don't know if the thought was originally federal jurisdiction. What it appears to be from what I've seen and heard and read, that FSU is basing its jurisdiction, step number 1, on Florida Statute 48.1931A1, doing a business. It's here somewhere. But that's the maintaining an office or doing a business in Florida section. It reads for itself. And I explained when Ms. Nunley and I were having a discussion what I thought the facts of the complaint showed. What I was doing, however, was giving my understanding of the facts from what I've gleaned from these day and a half worth of discussions, as opposed to what is in the complaint. Now, I know a Tier 1 game is a home game. That's not alleged in the complaint. That's just one point. I think it's a close call, but in a case that's this important to both sides, I don't believe that we should just proceed on with our eyes closed, thinking no one's ever going to be concerned about this, when in fact, FSU could replead this with more specificity and directness. Then we'll go. I already know the damage argument that ACC is going to make if I don't do this. They're going to contend on appeal that they were misled into thinking that it was federal diversity, and therefore they did not file affidavits. And since they did not file affidavits, they were prejudiced in presenting their burden of proof, the second prong, under the salami case. So to cure that and to get a better statement, and someone like me, who is not a football expert or a conference expert, can understand by reading the complaint what's being alleged. I know what the issues are. I understand those, but I have to limit myself to what's in the complaint. Now, I do know, as I said earlier, that sometimes in personal jurisdiction issues, you can bring in issues that are outside the complaint. That's after the burden shifts and you have to file your affidavits. The first thing you have to do, you can just name the number of the statute if you want to. I'll have to let people decide whether that's the best procedure, or plead the facts supporting the statute. Some people might do one or the other. Some more careful people might do both. Or they might not be more careful. They might be afraid if they do both, they'll be challenged with that. That's a strategy that's not up to me to decide. But I think in the jurisdiction section, and if it, Ms. Nunley, if it was just someplace else, I would have denied the motion. And can I say that a knowledgeable person couldn't sort of figure it out? That's a close question. Although I suspect smart people have already figured out that what they were referring to was 48.193(1A1). But that's not what is clearly alleged in the complaint. And there's at least an argument that can be made from the defense that in reliance upon the verbatim allegation, they were led to believe this was a diversity jurisdiction assertion and not the 48.193 long arm statute assertion. So the case is not over. The case will continue. I'm sure the news media will be happy to hear that this means we'll have another hearing on personal jurisdiction at some point. And here's the question I want to ask the parties. Do you want to go ahead with the rest of the motion to dismiss or not? Because there's going to be an amended complaint and there may be some allegation in the jurisdictional section which may have some interplay on other causes of action.
Your Honor, we would prefer to go ahead and talk now for exactly the reason that you just stated.
Mr. Rush, I suggest we don't go into the motion to the rest of the motion to dismiss.
We will not amend those allegations, Your Honor. We will only include a lengthy section on jurisdiction. We'll leave every statement in the complaint unchanged. Other than that.
Your Honor, we do also have the pending motion to stay discovery. That motion was asking to stay discovery pending a ruling on the motion to dismiss. We've now gotten that ruling. Of course, the complaint's been dismissed, and we assume that
With leave to amend.
With leave to amend, and we assume that they will do that, like Mr. Rush just said. So, if it's appropriate, we also get an order staying discovery at least until there's been an amended complaint, and then if we respond with another motion to dismiss, pending a ruling on that motion to dismiss.
I don't like delaying cases. I think it makes sense to stay discovery on all issues dealing with personal jurisdiction. But I think there can be discovery on other issues in the complaint. Well, it's sticky because we might have to have other hearings on this. I mean, issues on which there is no dispute raised in the motions to wait a second, I'm talking myself into agreeing to a stay. Mr. Rush, how can I don't think we should go further on the motion to dismiss until we get the jurisdictional step. I believe pleading is like running a race with hurdles. We're over the first hurdle, that's the ripeness hurdle. Hurdle number 2 is jurisdiction. We're not over that yet. Not saying that we won't be over that. And then the next hurdle are the motion to dismiss the various counts. I'm going to extend the motion to stay until I rule on the motions to dismiss. Don't see that I have any other option. We're going to rule on the motions to dismiss after the plaintiff files. Now, how much time do you need? You don't have to short time yourself, Mr. Rush. You tell me what time you want, and that's what I'll give you.
1 week, Your Honor.
1 week?
Yes, sir.
How about 10 days from the date of the order?
1 week is fine.
1 week? 1 week from the date of the order, so I'm going to ask defense counsel to give me an order. Motion to dismiss granted with leave to amend within 7 days of the date of the order. And I think I'm going to ask my former Supreme Court Justice here, have they changed that rule yet on if it's less than 10 days, you don't count weekends when I do a deadline?
I believe it's still the rule. If it's less than 10 days.
If it's less than 10 days, you don't count weekends. So it's 7 days excluding weekend days.
I believe that's right.
Yeah, well, let's put that in the order just in case. I do know the extra 5-day rule has been changed for service by email. Sorry for the non-lawyers in the room, but those are obscure points that lawyers love to talk about. So 7 days from the date of the order, weekends and holidays do not count in that calculation. Mr. Rush, you need more time. Get with defense counsel. I have no doubt they would agree to some reasonable period. If not, file a motion, send it to me. So that's where we are. You're going to get an order in a minute from me ordering mediation within 120 days. It was going to be 90, but I added 30 days because of the personal jurisdiction amendment issue. You all know what the issues are. You all know the jurisdictional issues, the motion to dismiss issues, the causes of action. At least some of you know what's in the ESPN agreement. There's plenty of information in the possession of the people here and their clients to engage in a good faith mediation. And that's a way of me saying, I'm going to deny your request for extension because you haven't had discovery. You all know enough to mediate. Now, if you engage in good faith mediation and there's some point that in good faith you can say we need to take so-and-so's deposition, then we can continue the mediation to do that. But I've been in lots of mediations. I've conducted lots of mediations. And the concept that it's too early to mediation rarely gets in the way of parties who have as much information as these parties have about this case occurs. So you're not required, so the public knows, a mediation is voluntary in the sense, it's not voluntary that you go to it, but the mediator cannot force the sides into an agreement. It's not like arbitration that some may have heard of. A mediation is to allow the parties and decision makers for the parties to get in the same room and start talking through their issues to see if there are ways that they can resolve the disputes which are acceptable. I never use the word that is pleasant or is a victory, because those words don't belong in the settlement negotiation. The word acceptable belongs in the settlement negotiation. So I send every case to mediation except mortgage foreclosures. This is not being done any differently. You talk to lawyers that I've dealt with here, and they will tell you that I like early mediation. And I believe in early mediation because litigation is expensive, and the longer people litigate, sometimes the harder it is for people to come to agreements, rather than the easier it is to come to agreements. Both sides have an interest in keeping the expenses of this litigation to a reasonable amount. Both sides have an interest in seeing if there's any way this dispute could be resolved quickly instead of over a long period of time. So that's where we are. Anything else y'all want from me, Mr. Rush?
Given that you were not staying discovery, we reserve the right to amend any and all allegations of our complaint.
Yes.
And what about a case management conference or a scheduling on a hearing on the motion to dismiss or agree to schedule?
You tell me when you're going to file. You let me know when the All right, what we haven't included is when does the defense, how much time does the defense want to respond to the amendment? And I assume that's going to be by motion.
Given that they may amend any allegations in the complaint, we'd like the 20 days that's generally allowed.
You need more than your 7 days?
No. Did you say
20? 20 days to respond from the time
file the
plaintiff emails to opposing counsel the amended complaint, And remember, when it's filed, it will show up on my computer in usually about 2 days. If you want me to see it sooner, you can have it delivered, or you can email it to my judicial assistant, and when she calls you and tells you to copy it, ask her to get with me, and we'll figure out a way to maybe copy it on a faster copier that we have here.
And you are the same if there are significant changes, and we'll get with them about additional time if we think it's necessary.
I don't have any doubt that the lawyers can handle that issue, but here's my point, Mr. Rush. Let me make a note here. I'm just going to leave a note to myself. Okay, so motion to dismiss as to, I'm calling it prong 1 of personal jurisdiction issue granted, 7 days from date of order to amend, which does not include weekends or holidays. Defendant has 20 days to respond from time of receipt of the amended complaint. And then set hearing ASAP after that. So plaintiff to notify me when amended complaint filed, and I'll get some hearing times. All right, so if you'll send me, or just let me know when the amended complaint's been filed, that will trigger me to, you might remind me, your office, in email, say, as you indicated, we're letting you know we filed the complaint, and we're going to look for some hearing dates because of that. So I'll do that within the time frame that the defense has, and we'll come back. So we're in April now. I'll do it whenever I can. This is a non-hearing week for me. You got a hearing, and I'm probably going to have to do it in non-hearing weeks because my hearings are being set now in like August and September. So I'll find a non-hearing week, usually a trial that's scheduled or a Friday when I don't expect the trial to go to Friday, and we'll set it then. So any questions? want to make sure everyone understands. The case is still going on. It's not over. A dismissal with leave to amend is a common order in civil litigation. It's not an unusual order in civil litigation. And once the complaint is amended, we'll look at that at a separate hearing, and we'll make a decision then on what to do, and then go forward depending upon the ruling. Anything else I need to say to try to drive that point home, counsel?
No, Your Honor. No, sir.
Okay. All right, thank you. Okay, we're in recess. Yes, ma'am. Don't pull your back out.
Okay, so see you in August or September. So we have a big old delay here. Again, I'm going to show you what Doug Rohan said here. I've been following his tweets throughout this.
Call from
BJ.
BJ, the floor is yours.
Hey, what's up, Greg? I have to say this. I've been duped. I think we have all been duped. The judge pulled a Columbo. Like, he was very just unassuming, shrewd kind of dude. But I think all along, he was covering his butt against the pill. I think that's why he went through all those different cases to cover himself. And he's a sharp guy. I didn't think he was this sharp earlier, but in this last kind of deliberation, to me, it was clear he was in control the whole time. I think he let the ACC walk into a trap. He allowed Florida State to kind of walk into a trap by overstudying. I think Rush he overstudied too much for the exam the night before, and he was just, I think the judge didn't want to hear all that, to be honest with you. But I think the Judge Cooper, from the get-go, wanted mediation, and he was very clear not to push it on the two parties, but to suggest it and allow time and space for it to happen. And he also used a very important term, good faith. Mm-hmm. He said both parties know all the information, right? We know what the numbers are. Sit in the room in a good faith, hammer this stuff out. So with that being said, I felt like I've been duped. I felt like I was watching an episode of Columbo because he stood up straight. He became more articulate. His posture changed and everything. So I'm happy that, he allowed Florida State to kind of redo their amendment. But I think we're not even going to get to that point. I think it's going to be settled, within the 120 days he kind of set out for the two parties.
Yeah, I said in the chat, I said that I believe that Judge Cooper is giving Florida State another bite at the apple, and he's sort of hinting to the ACC side, mediation, take advantage of it. You don't have to, of course, but whatever. This is what Doug Rohan said. Judge Cooper knows and understands the issues, but in such a high-profile case, he wants to get it right and not have an appellate issue where the ACC can argue if they were not placed on notice as to what they need to defend against. This is not ideal, Doug Rohan said, but this is more embarrassing than fatal to the case. Parties will be told periodically to do this, and other than delaying the case, it doesn't really have much of a bearing. The question was asked to Doug Rohan, correct me if I'm wrong, but I see this as a victory. He's giving Florida State a free pass to make a winning argument. They get a do-over. I don't care how the media portray it. They don't understand what is happening right before their eyes. And Rohan said, not a victory per se, but certainly a do-over. And you used the phrase do-over as well, BJ. Go ahead.
Yeah, and I think it's a do-over. And a little things I noticed. I think like when the judge, that last deliberation, he was looking directly at interacting directly with the ACC when he said these things cost a lot of money and it's easier to negotiate sooner than later. I think that was a clear dog whistle, for lack of a better term, to the ACC to operate in good faith. But I don't know how you took that, but he was positioned directly, at the ACC, lawyers when he made that statement.
Yeah.
But it's a do-over, and now if we can segue just a little bit how it pertains to how it affects the ESPN CFP stuff. I don't know. I haven't dug into that really, but the longer this plays out, I would imagine the ESPN folks are kind of shitting bricks because they're on the hook for a lot of money if they extend that deal in February of 25, and for a product that probably won't be deserving of the money that it's contracted to give to receive. I'm sorry. But it ended. The case ended how I thought it was going to end: mediation.
Mm-hmm. Well, we'll see what happens. Now, they don't have to go into mediation. This is not arbitration. They're not being forced. This is it's open to both parties, obviously. And he said I guessed that he was going to say the word mediation 6 times. I don't know how many times he said it, but that was my guess before today. It was somewhere around 6 times at least. So
I think he was spot on. I think it was around 6-7 times. Yeah. But so one last question for you, Greg. Did you see a different judge in his deliberations when he was handing out the stays?
I saw that on April 9th. You remember April 9th, how it all started? He was so confused and he couldn't figure out where his stuff was in the folder. His computer did not work at the beginning of April 9th. It did not work at the beginning of today, April 22nd. This is the second time he's done that, where he's either, maybe he's not a morning guy. Maybe he just gets his juices lathered up, kind of like an RB1 in college football. Give him the rock 15 to 20 times. He's better than his He's better than his first 5 rushing attempts during the game. Maybe that's how Judge C. Cooper works. I don't know.
But and then so give me an example. I remember doing earlier in the case today, where he was asking the Florida State lawyer to explain what he seemed confused about what tier 1, tier 2, and that stuff is. I think he knew all along that it wasn't explicitly called out in the case or in the filing. But then at the end, during the deliberation or the last piece, he's like, I know what a tier 1 is. Yeah. Very confidently. So I think he gives off this vibe that, oh, I'm just completely lost. What's the blue team? What's the team with the blue field?
Yeah.
But I think it's to make the lawyers comfortable, and so they can kind of, be themselves. But ultimately, I think out of everyone in that case, he has the most firm grasp of what's actually going on and what's really at stake. I think Florida State has a jaded view. I think ESPN and ACC has their jaded view. I think he is the only person in that courtroom that knows what the judgment will be if it goes to court. And I think he looked at the ACC lawyers for that reason in general and said what he said. It's going to be more expensive with litigation, and you might not like the result.
Yeah. All right, man.
Thank you for having me on once again.
Yep. I appreciate it. Appreciate it very much.
Bye-bye.
Great call. Thank you, sir. Interesting day. The evil badger, Ryan Willie, holy smokes. 10 gifted memberships. Wow. Unbelievable generosity given by the evil badger. You are hereby officially knighted cloak and dagger once again, Mr. Ryan Willie. B. Joe Peck, Christopher Counts, Tuffy Duffy, Storm Chaser 80, Dr. L. Smith, Dennis Haley, Mike Sheridan, Hidden, Hawaiian, and Tony Rodriguez. You are all hereby knighted cloak and dagger. Congratulations. You can go to our YouTube channel. Go to our membership-only episodes. Give them a watch, Cloak and Dagger. We drop a little bit of Cloak and Dagger before we come on live. Thank you so much, Ryan Willie, for the incredible generosity. A lot of great comments in the comments section. A lot of great comments. Holy smokes. Let me get to some of them here. Tide guy, even if North Carolina rules first, it doesn't end the case in Florida. Florida State will be getting a big win in Florida, so the ACC better listen to the judge and work on an agreement. Well, the good faith and credit clause, Tide guy, I'm just a fat guy from Minnesota. I don't quite understand it, but according to people who bring up the full faith and credit clause, it does have a significant impact on who does rule the case first. That Florida state of Florida might have to fold it up and agree with whatever the ruling on North Carolina. Look, I don't know either way on it, but it sounds like it does. It's a race to the courthouse to get it done first. There was a hiccup today in Leon County for Florida State. There might be a big hiccup on May 2nd. For the state of, for the ACC. Judge Bledsoe, right? This is going to bounce around and who knows, and there may be other delays in both Mecklenburg County and Leon County, and then you got Pickens County. By the way, I haven't even checked Pickens County. Hold on, everybody. Hold on. I got to see if that amended complaint has been filed yet. I have forgotten to check all day. I know there's something brewing. At least, let's check it out here. No, there is nothing. Nothing has dropped in. On April 17th, there's an amended summons and complaint. There was an electronic filing. The notice, it was for Axton Dylan Crawley. Filed by or on behalf of Axton Dylan Crawley for Clemson University. Everybody were served electronically And we're still waiting for that thing to drop. Now, either they're having something wrong with the docket or something, or maybe this is a sealed, maybe it's all sealed up somehow. I don't know. Now, it did take a while when Clemson filed. You know what? I don't want to go down that rabbit hole. We're just waiting for something to pop in Pickens County. So keep your head on a swivel when it comes to that. So there's a definite pause, a definite delay in the process at Leon County. Good morning, Greg, Hale, West Virginia. Thank Gorb for the super chat. Thank you for your generosity. I do appreciate it. Carson, he's not a morning person. Staying up late, drinking cocktails, and watching PATC. I think that's against the rule, right? I don't think the judge can watch an influential show like PATC when it comes to court rulings and all that, even though I don't know what the heck I'm talking about. Thank you, Carson. I do appreciate your generosity. I think, in general terms, I think the judge just... There is no direct victory here. There's a little bit of a victory for the ACC because the process got delayed. Let's be honest. But in terms of the judge is trying to give Florida State another bite at the apple, I think it's not really a big... I've always said... This case is not even about the grant of rights anymore. That is what is so incredible about this. Even Florida State's lawyer, Rush, said, grant of rights, we're not even trying to get it invalidated. We're just trying to go by what it says and then tie it to the media rights agreement. It's it's getting more fascinating as it continues on. And I think every day that goes by, I think it's a better case for Clemson and Florida State. I think ACC is going to want to settle. But then again, there's a lot of politics internally at ACC. What do the schools want to do at the ACC? Florida State lawyer Rush said at the beginning here, there's a lot of stuff that was said here that we haven't even been able to cover. But Florida State lawyer said, Rush said basically, They voted 3/4 vote to give us to file for $100 million in damages more against Florida State. So basically the lawyer was telling the judge right away, this relationship is never getting back together again. It's a very intriguing court drama today. A lot of fireworks, more than we thought. Now, we're going to have to close up this live show. I got to go pick up the little general, the moderator, the one who rules with an iron fist. Thank you for that. Henry Parrish going to Ole Miss. Damian Martinez sounds like he's going to Miami. Henry Parrish going to Ole Miss. Holy smokes. I like Henry Parrish. I like Lane Kiffin. I like Darks. I love Dart. Jackson Darts. They got a great transfer wide receiver. They're Ole Miss, baby. I got them what? I got the top 5 ACC teams are going to be fun to watch. Just going to be incredible. Georgia, Alabama, Texas, Missouri, and Ole Miss. I can't have Oklahoma in there. Their offensive line is the top 5 SEC teams. Georgia, Alabama, Missouri, Ole Miss. I left out LSU. How did I leave out LSU? Whatever. SEC is stacked. So anyways, I got to close it up, guys. We've had a lot of fun here. It's been amazing. We're going to be probably doing an episode coming on live, possibly later tonight, definitely tomorrow. So follow us here, Peek Around the Corner. If you've enjoyed our content today, please smash the like button. Please subscribe to our channel and open up your notifications because we can come on live at any time. Anytime we can come on live. We follow, we go where the story goes in all of college football. I want to thank everybody for their incredible generosity, their incredible donations. Really unbelievable. Thank you, Ryan Willie. Thank you, Kerry Goldnose. Thank you, everybody that gave us wonderful donations to help us keep the lights on. The great comments in the chat room. PATC, you are all legends in my book, and the wonderful phone calls that we had. We've been on the air for, 5.5 hours. And it's all concluded for today. But we're going to be having more hearings coming out of Leon County. And we're going to try to get you a live stream to Mecklenburg County on May 2nd. But look, keep your eyes open. Keep your head on a swivel when it comes to Pickens County, because something was filed by Clemson, an amended complaint against the ACC. We just can't see it yet. We just can't see it. And when that hits, we're going to be coming on live. So subscribe and have your notifications wide open. I appreciate it. Until next time, from all of us at PATC to all of you, please, you all take great care of each other. Thank you.